Good afternoon. I'll call on the Honourable Minister responsible for Finance and Economic Development to say prayers.
Thank you, Madam Speaker. Almighty God, from whom all wisdom and power are derived, we beseech Thee so to direct and prosper the deliberations of the Legislative Assembly, now so assembled, that all things may be ordered upon the best and surest foundations for the glory of Thy name, and for the safety, honor, and welfare of the people of these islands. Bless our Sovereign Lady, Queen Elizabeth II, Philip, Duke of Edinburgh, Charles, Prince of Wales, and all the royal family. Give grace to all who exercise authority in our Commonwealth, that peace and happiness, truth and justice, religion and piety may be established among us. Especially we pray for the Governor of our islands, the Premier, the Speaker of the Legislative Assembly, the Leader of the Opposition, Ministers of the Cabinet, ex officio members, and members of the Legislative Assembly, that we may be enabled faithfully to perform the responsible duties of our high office. All this we ask for Thy great name's sake. Let us say the Lord's Prayer together. Our Father, who art in heaven, hallowed be Thy name. Thy kingdom come, Thy will be done on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those who trespass against us. Lead us not into temptation, but deliver us from evil. For Thine is the kingdom, the power, and the glory, forever and ever. Amen. The Lord bless us and keep us. The Lord make His face shine upon us and be gracious unto us. The Lord lift up the light of His countenance upon us and give us peace, now and always. Amen.
Please be seated.
Administration of oaths or affirmations.
None.
Reading by the Honourable Speaker of messages and announcements.
I receive apologies from the Honourable Deputy Speaker, who's not here for today. And I also wish to take this opportunity to wish all the women a very happy International Day and to pay particular honour to the 10 women who have had the privilege and honour of serving in this honourable chamber, namely Evelyn Wood from 1962 to 1964, Anna Hulda-Bodden, 1961 to 1965, nominated, 1965 to 1984, elected, Esterline Ebanks, 1976 to 1980, Daphne Orrit, 1984 to 1988, Berna L. Thompson Murphy Cummins, 1992 to 1996, Honourable Edna M. Moll, 1992 to May 2009, Heather Bodden, December 1995 to 2000, Lucille Seymour, 2005 to 2009, Honourable Tara Rivers, 2013 to present, Honourable Julianne O'Connor Conley, 1996 to present.
Presentation of petitions.
None.
Presentation of papers and of reports.
None.
Questions to Honourable Ministers and members of the Cabinet.
Recognize.
Sorry. The elected member for Northside to ask the Honourable Deputy Governor, the ex officio member responsible for the portfolio of the Civil Service. Question number 31.
Recognize the Honourable Member from Northside.
Thank you, Madam Speaker. Madam Speaker, I beg to ask the Honourable Deputy Governor, ex officio member responsible for the portfolio of the Civil Service, the following question. Can the Honourable Deputy Governor, ex officio member, give an update on the review of the Royal Cayman Islands Police Service by the new Commissioner as promised by the Governor, and what, if any, changes and or additional resources will be provided for Northside Police Station?
Recognize the Honourable Deputy Governor.
Thank you, Madam Speaker. Madam Speaker, the answer. The Commissioner of Police took up his post on the 7th of November 2016. Since his appointment, the Commissioner has been reviewing current processes, policies, and procedures across the full range of policing business areas, including assets and estates, to inform the future strategic direction of the Royal Cayman Islands Police Service toward the delivery of a modern, progressive, professional, fit-for-purpose 21st century policing service meeting community demands and expectations. In discussions with the Commissioner, he has advised that his initial assessment has identified that the basic policing framework and structures underpinning current operations at the RCIPS are sound, but that there is a significant requirement to build capacity, capability, and resilience to meet societal and environmental demands and expectations. This requirement necessitates a full and detailed review of current resource allocation and deployment to identify and implement a best fit model for policing in the Cayman Islands. As highlighted above, assets and estates are key components of the review, and a service delivery model is being developed. The Commissioner has advised that he has identified critical skill gaps and vulnerabilities impacting on the capacity of the Royal Cayman Islands Police Service to deliver an effective and efficient policing service to the people of the Cayman Islands. I am aware that the Commissioner is currently attending to his review and will provide a strategic document in the coming months to inform the future strategic direction of the RCIPS. Turning to the Northside Policing District, you will be aware that early in his tenure, the Commissioner reopened the Northside Police Station and allocated 2 police officers there. The Commissioner has advised that he will keep this matter under review to ensure that available resources are used to optimum effect across the Cayman Islands. The Commissioner has further advised that he is currently examining the feasibility of reopening the East End Police Station, staffed with a complement of 2 police officers to meet service demands in that district. Further, the Commissioner is contemplating the completion of minor repairs at both Northside and East End police stations to upgrade official accommodation facilities with a view to having a police officer reside in the accommodations at each location. This added presence would be intended to bolster engagement and partnership with the surrounding community. Finally, Madam Speaker, the Foreign and Commonwealth Office has commenced a security review of the Cayman Islands, the outcome of which will assist the Commissioner to set out the future strategic direction of the Royal Cayman Islands Police Service.
Are there any supplementaries? A member from Northside.
Through you, Madam Speaker, I wonder if the Deputy Governor could confirm the period of time that these 2 police officers were assigned to the Northside Police Station.
Honorable Deputy Governor.
Madam Speaker, if I could just consult.
Certainly. Honorable Deputy Governor.
Madam Speaker, unfortunately, I don't have that information, but I can give an undertaking to get it for the member. And just to clarify the question, is it when they were stationed there or the hours of operation of the station?
Honorable member from Northside.
How long they were stationed there? Because does the Deputy Governor confirm that the only time the police station in Northside was open with officers present was for the 1 week that it was used as a staging area to investigate the 8 robberies that occurred in 1 week? And is this the period of time when they were riding bicycles up and down in Rum Point? And what is the current position? Are there officers at the police station today?
Honorable Deputy Governor.
Thank you, Madam Speaker. I would have to consult outside of the chamber on that, and I will give a response to the minister or to the member in writing afterwards.
Are there no further supplementaries? Member from Northside.
Madam Speaker, I wonder if we could suspend and she'd get the Chief of Police to come down here to answer these questions. Because this is a very long and drawn out answer that says nothing. And the question was asked, what specific resources due to his review are being allocated to Northside?
Before calling on the Deputy Governor, can we just get can I call on the Honourable Deputy Premier to move the suspension of Standing Order 23, 7 and 8 to allow question times to continue beyond the hour of 11 a.m.?
Thank you, Madam Speaker. Madam Speaker, I move the suspension of the relevant standing order. Take questions after 11.
The question is that Standing Order 23, 7 and 8 be suspended to allow question time to continue beyond the hour of 11 a.m. All those in favour, please say aye.
Aye.
Against, no. The ayes have it. Accordingly, Standing Order 23, 7 and 8 is hereby suspended. I call on the Honourable Deputy Governor to respond to the member from Northside.
Thank you, Madam Speaker. If, with the leave of the House, we can call the Commissioner of Police and have him come down if you want to suspend dealing with this question for the moment until he arrives, and we can maybe move on to the next question.
Do you have an idea how long it's going to take for?
No, Madam Speaker. I do know that he was standing by in case we needed him. So we've just gone to call, and we can advise once we've spoken to him how soon he would be available.
Honourable Member from Northside, is it your wish to have the House suspend for him to come, move on to another question, to the next question or the paper, or defer the question until tomorrow?
Madam Speaker, I don't have a difficulty with that. If he can't come now to answer the questions, then I would want the question to be put back on tomorrow so that he can be here to answer the question. Huh? Oh, okay.
Okay. So I take it that we will go to the next question, Madam Clerk, and whenever he's here, we'll deal with that. Is that the will of the House? Okay. Madam Clerk.
The fourth elected member for Boydentown to ask the Honourable Deputy Governor, ex officio member responsible for the portfolio of the Civil Service, question number 32.
I recognise the Honourable Member, fourth elected member from Boydentown.
Thank you, Madam Speaker. Madam Speaker, I wish to ask the Honourable Deputy Governor, ex officio member responsible for the portfolio of the Civil Service the following question. Can the Honourable Deputy Governor please state, A, whether or not the Deputy Director of Her Majesty's Prison Services has been reinstated to active duty? B, if so, was there a settlement offer? And C, if so, what are the details of that settlement? Thank you, Madam Speaker.
Honourable Deputy Governor.
Thank you, Madam Speaker. The answer? The Deputy Director of Rehabilitation at Her Majesty's Cayman Islands Prison Service returned to active duty on February 20th, 2017. A deed of release and settlement was signed on February 10th, 2017 between the Chief Officer, Ministry of Home Affairs, and the Deputy Director of Rehabilitation. The details of the settlement are summarized as follows. A sum of 15,000 Cayman dollars will be paid to the Deputy Director by the Cayman Islands government as it relates to legal costs incurred. The Chief Officer will issue a letter stating that there are no findings of misconduct against the Deputy Director. The Chief Officer has undertaken that no further disciplinary proceedings will be instituted against the Deputy Director in relation to the incident in question. The Deputy Director will not institute legal proceedings in relation to defamation, constructive dismissal, breach of contract, as well as any other outstanding employment or other claims and/or any other related claims arising out of the facts outlined in the deed of release. The Chief Officer undertakes not to publish any adverse statement about the Deputy Director which may have the effect of damaging or lowering her reputation concerning any matter connected to her employment in relation to this incident with Her Majesty's Cayman Islands Prison Service.
Are there any supplementaries? Member from Easton.
Thank you, Madam Speaker. Madam Speaker, I wonder if the Deputy Governor can tell us if an investigation has taken place into how this situation got to the point where it had to go to court to do a judicial review.
Honorable Deputy Governor.
Madam Speaker, if I may consult.
Honorable Deputy Governor.
Thank you, Madam Speaker. I've been advised that the ministry did review the situation leading up, or the investigation leading up to this situation, and we're satisfied the necessary steps have been followed. And just to clarify that the matter was not before the courts at any time. It was handled outside of the courts with the support of the Attorney General.
Member from Easton.
Madam Speaker, I am stumped because it was reported in the papers that the judicial review said that the person was not properly dismissed and she must be put back on the job until such time. Which court was that? May I ask?
Honorable Deputy Governor.
Madam Speaker, if I may have a moment to just confirm that.
Honorable Deputy Governor.
Thank you, Madam Speaker. Apologies for the delay. There was a correction that was issued by Government Information Services after the media story had gone out, which reads as follows. Please be advised that in the matter of Aduki Natalie Joseph Caesar, the Grand Court never made any orders or findings in the previous judicial review application, as many media houses are reporting. Also, please note that the Grand Court did not order any back payments of salary or costs. A consent order was entered by both parties.
Member from Easton.
Madam Speaker, and this is a question, is this consent order was a direct result of the judicial review that the real deputy governor told me that would have made, when I started questioning him here, would have made it sub judice? Because it was the parties were going to get a judicial review.
Honorable Deputy Governor, did you say there was an application for judicial review, but it was pretty much a novus actus and a venus and a consent order? What I don't know, member from Easton, obviously, because the person that you refer to as the real Deputy Governor is not here, whether at the time he answered you the application for judicial review were in. But please proceed.
Madam Speaker, maybe the number of lawyers in here and the Deputy Governor can tell me if this case, Acting Deputy Governor can tell me, if information on this case can be accessed through FOI.
Honorable Deputy Governor.
Thank you, Madam Speaker. Under the Freedom of Information law, anyone is free to make whatever request for a record that they deem or that they would like to see. Obviously, any FOI request would be reviewed by the information manager and any relevant exemptions applied to it. I haven't had sight of the detailed agreement, so I wouldn't be able to say now whether it would be released entirely or in a redacted form, but I would assume that there would be some redactions to it if it were requested under FOI due to the exemptions available in that law.
Member from Easton.
Thank you, Madam Speaker. Madam Speaker, the Deputy Governor, not the acting Deputy Governor, the Deputy Governor, in a response to a supplementary by myself some time ago, told me that no laws were broken. Is the Deputy Governor and the government still of that view?
Honorable Deputy Governor.
Thank you, Madam Speaker. Could I ask for a clarification from the member, please, in terms of, is he asking whether there was a view that there should be a case made for prosecution and that as a result of the negotiations it was decided that there was no basis for that?
Member from Easton, could you please clarify?
Madam Speaker, upon the news breaking that there was some infractions, should I call them, at the prison, I submitted a question and asking for an update on whatever that was that had happened at the prison. The Deputy Governor, in his response, assured this honorable House that no laws were broken. I brought to the attention of this honorable House the provisions in the prisons law, which says that only the prison director can discipline prison officers. I questioned the Deputy Governor, asking him if that law was broken, because the news that broke in the papers said that she was dismissed by the chief officer. I am asking if the government still holds that no laws were broken.
Honorable Deputy Governor?
Madam Speaker, if I may have a moment, please.
Yes. Honorable Deputy Governor?
Thank you, Madam Speaker. Madam Speaker, I've been advised that the member is correct and that the prisons law speaks to the provisions for all persons involved in administering the prison, and that the individual's role could be captured by that. The challenge is that there is a conflict with the prisons law and the public service management law, and the civil servant was hired by the chief officer under the provisions of the public service management law, which was why when she was initially dismissed, it was by the chief officer. Subsequently, she was reinstated.
Honorable Member from Easton, allow 2 more questions.
Madam Speaker, I have wrapped a couple of them up in those 2 then.
I'm sure you can do that quite well.
I have been known to do that, yes. Madam Speaker, that did not satisfy my question, but that's the nature of this thing here. I should remind everybody that omissions are acceptable, but commissions are not. Madam Speaker, can the Deputy Governor say when this lady was reinstated, the date she was reinstated, and subsequently returned to work, and between the letter of commitment and settlement and when to date, prior to her going back, or to date, has there been any further interventions between the Deputy Director and the government?
Deputy Governor?
Thank you, Madam Speaker. If I could just ask to clarify, is the member asking if there's been further disciplinary proceedings since she's returned to active duty. When you mention interventions, I'm just not sure what's meant.
Honourable Member from Easton.
Madam Speaker, it covers all of those, whether it's mediations or requests to have further discussions subsequent to the agreement being made.
Honourable Deputy Governor.
Thank you, Madam Speaker. That is information that we unfortunately don't have with us. That would be something we would have to consult the Director of Prisons to find out about.
So are you saying the chief officer didn't deal with it? It was the director of prison that dealt with it and he's not present?
Thank you, Madam Speaker. No, what I meant was the Director of Prisons would be her day-to-day line manager. So he would be, if she was having discussions with her line manager, he would be the one. And as far as I'm aware, there's been no discussions with the chief officer since her return to work. Sorry, I'm just confirming that.
Member from Easton.
Madam Speaker, these are matters of concerns being raised by members of the Legislative Assembly. And in the absence of answers being provided, we are unable to carry out our job in an efficient manner, an effective manner. Madam Speaker, it is incumbent upon the government to ensure the requisite resources, human and otherwise, are available to answer these questions. I am a little bit concerned about that. Maybe, Madam Speaker, can I request that the Director of Prison come and answer, and the Chief Officer come and answer these questions?
Today. Is that request for today?
I shall bow to your ruling, Madam Speaker.
Can I respectfully ask you to consider that perhaps it could be put on for tomorrow since the prison is in Northward? And you may wish to have them here both at the same time?
Madam Speaker, I'm at the will of the House. I certainly do not wish to impose my will on the House or the civil service if it is not in keeping with any degree of efficiency for them. I don't want to impose that on them, but I want the questions answered. So I'm at the will of the House.
Honourable Deputy Governor, can you get them here this evening in a short order?
Thank you, Madam Speaker. The Director of Prisons is actually off island this week, so he would not be available. But if the member, we can undertake to provide a response in writing to the member to his question.
Member from Easton, would you be, please proceed.
Madam Speaker, no response in writing is not the answer. I would like to find out when the prison director or the chief officer might be able to answer the questions. The chief officer that is in charge, he's off island too. He or she, whomever that may be.
Honourable Deputy Governor.
Thank you, Madam Speaker. The prison director is back next week, and the acting chief officer is actually here with me in the chamber this afternoon and has been advising me.
Member from Easton. One is absent, one is acting, so take your pick.
Madam Speaker, I don't want to act and director of prison now either, because it looks like we're having a Hollywood day. Lots of actors. Madam Speaker, I believe I shall revert to the will of the House. If nobody can answer it and these people are not available, Madam Speaker, it'll go in to next year. Or maybe when the time comes that the director's back, if we are still here by next week, which I suspect we should be, then I would respectfully ask that the House require his presence upon his return to the island.
Can we get an indication from a government minister? As to the will of the House, it would take a motion for the question to be deferred until next week when the Director of Prison returns. Number 32.
Madam Speaker, the government is happy to defer the question until next week. Madam Speaker, it's the availability of the people that are able to answer the questions that the member from East End is asking for. And that's why the deferment until next week when they're back and in position to do that.
Madam Speaker, I thought
Member
it was...
from Easton.
Thank you. Madam Speaker, I thought it was specific, the Director of Prisons that we were talking about, not the people.
That's the question I'm about to put. That
Okay.
question number 2 be deferred until the return of the prison director to this honorable chamber next week. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Accordingly, the House has voted for the prison director to make an appearance before the Honourable House upon his return next week to respond to inquiries as it relates to question number 32. Is the Commissioner of Police in the precincts? Or okay. All right, well, Madam Clerk, we'll move on to item 7 until the Commissioner is in the precinct.
Statements by honourable members and ministers of the Cabinet.
None. I recognize the Honourable Minister for Women Affairs, Gender Affairs.
Thank you, Madam Speaker. Madam Speaker, on behalf of the government and the Ministry of Education, Employment and Gender Affairs, and the Minister for and Ministry of Community Affairs, Youth and Sports, we wish all women in the Cayman Islands a happy International Women's Day. The government is pleased to support this year's theme, Be Bold for Change, because it calls for courageous and urgent action from all of us to take up the challenge to build a gender-inclusive world. Madam Speaker, International Women's Day is a platform to inspire women and men to make a difference in their communities, stand up for justice and change, and to be a voice for those who cannot speak for themselves. This day is also a great opportunity for us to show our appreciation for those women, and just as significantly, those men and organizations that actively strive for the betterment of our islands. In delivering this message, we acknowledge that we must unite to achieve gender equality because gender equality benefits everyone. The Gender Affairs Unit and the Department of Counseling Services Family Resource Center, though in different ministries, have similarly worked together in shaping today's International Women's Day celebration event. As the major sponsor of the International Women's Day celebration, the Ministry of Gender Affairs was pleased to lend support to the Family Resource Center by helping to bring this year's keynote speaker, Dr. Jackson Katz, to our shores. A renowned anti-sexism educator and activist, his pioneering work in the field of gender relations certainly reflects this year's theme in asking us all to take personal responsibility and be bold for change. We hope to benefit from his research, and we are particularly interested in how his work can be harnessed to actively promote men's participation in gender equity in our community. You may ask, as a government, how have we been bold for change? As the Minister responsible for gender affairs, I'm pleased to report that over the past few years, the Cayman Islands have experienced several firsts of its kind through the work of the Gender Affairs Unit in my ministry. These include work such as hosting the first ever National Conference on Women and Girls in 2014, in March of that year to celebrate International Women's Day in 2014, by providing for the first time professional development on gender mainstreaming in the education system at the 2015 National Education Conference held, whereby educators were taught to build their capacity in understanding and using basic concepts and tools related to gender mainstreaming and gender analysis in the classroom, thereby helping them to better understand gender dynamics and its effects on the performance and experiences of our boys and girls in school. By introducing a national minimum basic wage for the Cayman Islands. Madam Speaker, the national minimum basic wage is a first for this country, and many of those affected by it in the lowest paid workers bracket are women. And the fact that domestics, who are the majority, usually women taking on those roles, are included in the minimum wage provision. And this speaks to equally valuing the work that is traditionally done by women in our society. In March 2016, the United Kingdom agreed to extend the Convention on the Elimination of All Forms of Discrimination Against Women, commonly known as CEDAW, to the Cayman Islands. This convention will help to ensure that as a country, we continue to work to eliminate discrimination against women in various areas as identified at the National Convention or the National Conference on Women and Girls held, as I said, in March of 2014. By hosting an event on the 30th of November 2016 to officially recognize Women's Entrepreneurship Day for the first time in the Cayman Islands, we celebrated and highlighted the achievements of women entrepreneurs in our society and their contribution to our economy. And Madam Speaker, I'm very excited to inform this Honourable House that this year we are creating a documentary which chronicles the women's suffrage movement in the Cayman Islands, the process which began in the late 1940s, leading to women eventually being given the right to vote a decade later and to participate in the general elections. Madam Speaker, this documentary is particularly timely given that this is an election year, and I hope that all women and men exercise their democratic right to vote, a now right for women that was fought for by a number of courageous women who dared to be bold for change over 60 years ago. A preview of this documentary will be aired this evening at the official International Women's Day event being held at the Marriott Hotel. Madam Speaker, highlighting Caymanian women and the bold decisions made which have significantly changed the political landscape of these islands, this film charts the local women's suffrage movement. An educational tool, it will be used to reach diverse audiences to spark discussion and explain women's voting rights, entry into politics, and other major achievements initiated by Cayman's gender equality pioneers. Hopefully, Madam Speaker, the film will inspire boys and men, girls and women to also become change agents through involvement in civic movements and take personal responsibility for being the change they themselves want to see. Let us continue to engage in confronting and addressing the corrosive effects of inequality in our homes, classrooms, our boardrooms through to the courtroom, to enlighten our citizens in the positive economic and social potential that will be unleashed once gender equality is fully realized. We must not only win over new converts, but re-inspire each other to continue to strive for what is right. Madam Speaker, this is why the Gender Affairs Unit's documentary, Her Story is Our History, is so apt. We urge you to take part in honoring Women Month and use this opportunity as your own catalyst for taking concrete action to move our society closer to gender parity. We encourage you to visit the Family Resource Centre's Facebook page for further details on the planned activities for the month. Madam Speaker, on International Women's Day, we also take this opportunity to thank the Gender Affairs Unit, the Department of Counselling Services, the Department of Children and Family Services, and all community welfare agencies for their efforts in continuing to champion the rights of men and women, girls and boys during trying times. Let us be bold not just today, but every day, so that we can each play a part in furthering gender equality in the Cayman Islands. Thank you.
Personal explanations,
None.
obituary and other ceremonial speeches,
None.
raising a matter of privileges,
None. I'm just trying to ascertain how long it will take for the commissioner to be here, because once I commence on bills, I can't go back into the questions. So if it's going to be just a few minutes, if it's going to be longer, I may have to ask a member if he would be willing to put off until tomorrow. I've been advised from the government side that he's on his way, but I have no idea whether that's 5, 10 minutes, half hour, and we need to move on to bills. Honorable member from Northside, can you
Madam
assist?
Speaker, I wouldn't want to have him come here and for nothing, so let's give him the half hour and suggest he get a police escort to move him through town with some red and blue lights.
In other words, that the interpretation is that we'd have to suspend for a half hour, because if once I go into bills and debates, the question dies for today. Honorable Premier, can you?
Madam Speaker, I still have no indication as to when the Commissioner will be here. I would suggest that we defer the question until tomorrow, and we can make sure he's here at the start of the proceedings, rather than lose another half an hour of the House's time.
The question is that question number 31 be deferred until tomorrow mornings to allow the Commissioner of Police to be present to respond to questions that may emanate therefrom. All those in favor, please say aye.
Aye.
Against, no. I believe the ayes have it. Question number 31 is deferred until tomorrow morning. Madam Clerk, next item, please.
Government business, bills, second readings.
Recognize Honorable Premier.
Thank you, Madam Speaker. Madam Speaker, given the importance of and the continuing controversy surrounding the Legal Practitioners Bill, the government has resolved that I should move, Madam Speaker, to promote the Legal Practitioners Bill 2016, which is item 20 on today's order paper, above item 1, which is the supplementary appropriation July 2013 to June 2014 Bill 2016, and that the House begin debate on that bill immediately.
Member from Easton.
Madam Speaker, the government has proposed to do this and they must be knowledgeable of the fact that we would not be prepared at this time to debate this bill, since we received a order paper last night, albeit draft, being in the position that it appeared on the actual order paper today. And in so doing, in so receiving, we recognize that the House would not reach that bill today. So we did not come prepared with all our notes. If the government insists on doing this today, then it is fair to the opposition that the opposition be given a fair opportunity to retrieve its documentation to debate this bill, because it's obvious the bill will not be finished today. I would like, if the government would respond to that, our request to have this put back where it was, or further down on the order paper, in order that, because, Madam Speaker, Mr. Miller has to go all the way to the north side. And it is highly unfair to the opposition to come here, not be prepared to debate, and the government pulls this on this honorable House, debates it, and votes it with its majority, and don't give the opposition the opportunity to have its say. So I appeal to your good self as presiding officer, Madam Speaker, in the interest of fairness to the opposition, because the opposition must be treated fairly within these honorable chambers also.
Does any other member wish to speak to the proposal from the government before the Honorable Premier replies? Does any other member wish to speak? Final call, the member from Northside.
Madam Speaker, last week, Thursday, when we were trying to rearrange the private member's motion to place what we regarded as the most important motion at the top of the list, the request was not even entertained. I find it a bit unfortunate that I have been here since 9:30 this morning. And all of this time, the government was planning to do this or had decided before they came here to rearrange the order paper. Madam Speaker, I would have thought that just out of common decency and respect, because had I known that between 9 o'clock and the start at 2 o'clock, I could have went and gotten my papers and been prepared to debate the bill. This is a very important piece of legislation, and unless the government is doing this to curtail the debate and hope that we may not be in a position, catch us off guard, so that we will not be in a position to make a proper contribution to the bill. Madam Speaker, I am not going to support rearranging the order paper at this moment.
Does any other member wish to speak? The fourth elected member from Bawden Town, I beg your pardon.
Thank you, Madam Speaker. Madam Speaker, I also want to rise to give support to my colleagues in expressing concern for this last-minute change. Madam Speaker, this is a democracy. This is not a dictatorship. Every one of us has to respect the other. The role of the opposition members is equally important to the role of the government members, Madam Speaker. And I think it would only be fair that if we're going to have a debate on this very important bill, Madam Speaker, that all sides have equal opportunity. As some of you may laugh and think that that's funny. However, I'm being very clear and serious, Madam Speaker. This is a serious change that is being considered here to this order paper, and to try to catch the opposition members unaware and unprepared simply means that we're going to have a one-sided debate. I would much prefer that we move this down so that even tomorrow it can occur. But I really don't think it's fair to the honorable members of this House for us to make this change now, and I will not support it. Thank you.
Does any other member wish to speak? The fifth elected member from the District of Georgetown.
Madam Speaker, I guess they say politics is war. So this must be the first shot. Madam Speaker, it's highly irregular. Well, I was going to get to that, but, well, let me just go to that. And disrespectful to the opposition. The government is doing what it said it would do in October, which it had the majority, so it made the rules. And I'm happy to debate this on any stage. But if this was part and parcel with a draft order paper sent out last night, and we were here from 9:30 this morning, and have the government sit out all morning till 2 o'clock, and now come with this. Madam Speaker, I guess that great word transparency is something that we just say willy-nilly. I would hope that those viewing this honorable House, and those listening to the proceedings of this honorable House, understand what's happening here. And that even though the government has the numbers to pass this, that be noted. Because there's a lot of been said about this bill, and I absolutely acknowledge it's of grave national importance. But to try to do it this way, especially when you have the numbers, especially when you can pass it at any time, I hope the Caymanian people, the Caymanian lawyers are watching. Madam Speaker, I will not support this. I will never support this. And I want that emphatically on the record.
Does any other member wish to speak? Does any other member wish to speak? Final call, the third elected member from West Bay.
Madam Speaker, we too, in the official opposition, find it highly strange that last week, when it was asked to change one day right unearthing, it was not agreed or not even considered, and all of a sudden this has popped upon us. Two members looked at the order paper for today, and they're presently meeting with constituents and won't be here to say what they have to say on it as well. So we too do not agree with it as well, ma'am.
Does any other member wish to speak? Does any other member wish to speak? Final call. Does any other member wish to speak? If not, I'll recognize Honorable Premier to reply.
Thank you, Madam Speaker. Madam Speaker, I hear all of the members on the other side suggesting that somehow this move is intended to prejudice their ability to make their presentations. I wish to assure them and the House and all who listen that that is not the case. I know those members understand that that is not the case. They have been, not the third elected member from West Bay, but the rest of them have been up and down every talk show in Cayman for the last 2 weeks talking about these issues. So I know none of this is catching them by surprise. Indeed, they admitted they sought to have these issues moved more quickly through this Honorable House by promoting their motion on essentially the same set of issues last week. So all of this claim and these protestations about being unprepared, as far as I'm concerned, are a bit disingenuous. But that aside, Madam Speaker, even if that is the case, it is not the government's intention, I wish we could do so, to push this debate through and have this bill voted on this evening. It is now 20 minutes to 3. We know what time the House will rise. In fact, we'll probably have to rise a bit earlier because members have other important public engagements this evening. So, Madam Speaker, the government spent this morning talking about how we deal with this because of the huge amount of public concern there is in Cayman, in London, from which I just returned last night, about what is happening in Cayman with respect to the legal profession in particular and the financial services industry in general. The fifth elected member from Georgetown well knows how serious this is. He was in a meeting with the Chief Justice along with the Minister of Financial Services till nearly 10 o'clock last night on the same issue. We have to understand that more important than our individual political positions and where we hope to get to is the concern about the future of these islands and our people and the financial services industry. For those who don't seem to appreciate it, is 60% of GDP and 40% of government revenue. It employs thousands of our people. We have taken a decision as a government, a principled decision, that we are not going to let this linger anymore, because the longer it carries on, the more damage that is done. So the proposal from the government, Madam Speaker, is that we will present the bill, and those members on the government side, assuming there is time, who wish to speak, will speak. And we will then continue tomorrow and the rest of the time it takes to have this bill taken to its vote and completion, and we put this matter behind us. If members on the other side are not in a position to speak this evening, the government is not going to insist, nor are we going to take this matter to a vote. We will simply continue the matter tomorrow and through the remaining days necessary for it to be dealt with. We know that this is going to take days, if not a week, to deal with. There are more than 100 amendments being proposed by members on the other side, not to mention the substantial committee stage amendments that the government has already circulated. So all of this talk and complaint about somehow the government is trying to sneak one on the opposition is just political posturing. Madam Speaker, I ask members for once, to put the public interest beyond their own political interest. And let's get on with the business of this House and do what is right by the people of this country.
Procedural.
If it's procedure, go ahead. If it's going to be speaking further to the motion, I don't have the discretion to allow that.
No, I'm not speaking to the motion. He already said when you say we know power is majority has rule, and that's what he's using. Madam Speaker, the Premier said that he's going into tomorrow on the debate on this. One, is he going to forego the private members' day? And two, we have all of these amendments and they are yet to be circulated. What is happening about that? When will they be circulated? Because it appears like the government is circulating a lot of amendments on every bill. The amendments from myself were submitted a very long time ago. When will they be circulated? If this government is overpowering Parliament to hear this, then the amendments should be circulated also.
Member from Eastern, as you would full well be cognizant of the standing orders. Thursday is private members' day, and that would be the case unless a motion is moved by either side to suspend the standing orders, and that will be dealt with when we come to that tomorrow. As far as the circulation of the amendments that you've put forward, I'll have to ask Madam Clerk to assist me with that response. As you know, it's done through administrative. And I know that they have been received, but you would also appreciate that it's a substantial amount of complex amendments, and the clerk and the deputy clerk will have to go through them to make sure that they're in order. So let me just check with the clerk as to what stage it's at. Madam Clerk. Honourable Member from Northside, I'm reliably informed by the clerk that the amendments will be circulated tomorrow. I'll now put the question that item number 20, as it appears on today's order paper, being the Legal Practitioners Bill 2016, be changed to place first on the order paper to be debated in that order. All those in favour, please say aye.
Aye.
Against, no.
No. Nope.
I believe the ayes have it.
Madam Speaker, can we call for a division, please?
Most certainly, Madam Clerk. Can we have a division, please?
Honourable Aldine McLaughlin.
Aye.
Honourable Moses Colonel.
Aye.
Honourable Kurt Tibbetts. Honourable Osborne Bodden.
Aye.
Honourable Wayne Panton.
Aye.
Honourable Marco Archer.
Aye.
Honourable Tara Rivers. Honourable Roy McTaggart.
Aye.
Honourable Joseph Hugh.
Aye.
Honourable McKeeva Bush. Mr. Barney Bush.
No.
Captain Eugene Ebanks. Mr. Alvis Sakou.
No.
Mr. Winston Connolly.
No.
Mr. Ezra Miller.
No.
Mr. Orden McLean.
No.
Honourable Anthony Eden.
The results of the division are as follows: 9 ayes, 5 noes, 3 absentees. The motion is carried. Item 20 now becomes item number 1. What I would say, honourable members, based on the submission from the Honourable Premier and the discourse that has emanated therefrom, that the debate on the bills will commence this afternoon, and should, for whatever reason, members do not respond to when I put the question, when I asked, does any other member wish to speak, I will not put the question on this bill until tomorrow. If the motion is not carried for whatever reason, to suspend, to allow the government business to take precedence over private members' vision tomorrow, then I would only put the question after members of the opposition or members of the backbench have had an opportunity to have all of the necessary aids for full debate, because it is a matter of national importance. Madam Clerk, please continue.
The Legal Practitioners Bill 2016.
I recognize the Honourable Minister responsible for financial services.
Thank you, Madam Speaker. I beg to move the second reading of a bill shortly entitled the Legal Practitioners Bill 2016.
The bill has been duly moved. Does the Honourable Minister responsible for financial services? Member from Easton.
Madam Speaker, may I bring to your attention section
Are you in a constitution or the standing orders?
No, Madam Speaker. The standing orders, standing order 83.
Pecuniary and professional interests?
That's correct, Madam Speaker. Madam Speaker, the member who is currently moving the second reading of this has been known to be, of this legal practitioners bill, has been known to be a owner, equity partner in Walkers.
Member from Easton, for the record, the member moving the second reading of the legal practitioners bill is the same member who was slated from the first reading of the bill. There have been no change. I noticed you said the current member. You want to elucidate on that?
Madam Speaker, I shall. Any person who is believed to have a pecuniary interest, personal pecuniary interest, cannot speak or vote on any such matter. There was no speech thereon for the first reading. It was deemed to have been read under the first reading.
I understand that, but you're also taking a point based on Standing Order 83 and the sub-standing orders thereon. So the onus is on you to show that there's a direct or personal pecuniary interest. So I wait to hear.
I thank you, Madam Speaker. Madam Speaker, it's common knowledge, and the member, I have not researched his register of interest, but the member has said in the public that he is part owner of the building that Walkers is in. And Walkers is one that Walkers is housed in. And Walkers is one of the large firms that this new practitioners bill and the controversy that the leader, the premier, has said that this bill has brought to this country relating to large law firms practicing overseas. Walkers just happens to be in the category of one of those. Thus, it is our submission, it is my submission, that the Minister for Financial Services, who is part owner of that building, has a personal pecuniary interest. Secondly, Madam Speaker,
Member, before you go on,
Okay.
because I want to make sure I follow your reasoning, is it your position that the member is a landlord, or is he a partner of a company being W.S. Walker and company or whatever they're called?
no,
Because there is a distinction.
it is my understanding that he's a part owner of the landlordship of that, if that is the correct way to put it. He's part owner, so he derives pecuniary dividend from the rent being paid on that building by Walker's, who is one of the large law firms.
And is it your opinion that that's a direct or an indirect?
It's a direct, Madam Speaker, because certainly...
Can you continue to speak to persuade me?
Okay, Madam Speaker, certainly it affects his financial position if Walker's is not allowed to practice overseas. Then that is less money for Walker's to receive. So who's to say that Walker's will not have to downsize and move out of his building? Therefore, there's a pecuniary interest. You can groan as much as you want. You want politics? Politics it is.
Please continue.
Madam Speaker, in my last submission on this matter, and I will move the motion if you so choose to do so, and let them vote, and then we'll do the subdivide. I can't move a motion. You watch me. You move it, I can move it.
Member, please
Madam
keep your
Speaker,
comments to the chair.
Madam Speaker, in all of my research on this honorable House, in all of my years in this honorable House, anything to do with legal matters must be brought, or has always been. So the convention is, the reason we have an Attorney General here is to advise on legal matters and head of the legal profession, industry. Therefore, there is no place for him to be the Minister for Financial Services to be bringing this bill. It, from a convention perspective, from a practice perspective, it has been the Attorney General as far back as my research took me, which was to 1982. The Attorney General's has always been the one that brought any matters to deal with the legal practitioners bill. So I certainly have my concerns as to why his constitutional responsibility is not being carried out and has been taken over by the Minister for Financial Services. He does not have constitutional responsibility for the legal fraternity, nor legal advice to the government, or, as the Constitution says, to the Legislative Assembly. And this matter relates to the legal profession and the legal industry. And besides that, Madam Speaker, the question that should be asked is, we know how these lawyers, especially those in equity position and managing partners, when they leave firms, their payout is over a lengthy period of time. Maybe the minister needs to explain if his retirement payout has been completed, because that is a direct pecuniary interest. And of course, those are those binding and non-disclosure matters. But it does not mean, Madam Speaker, that I cannot question it, or any member for that matter, can question the pecuniary interest of any other member. And those members speaking or voting on any matter that affects their pecuniary interest. Madam Speaker, on those two, I submit to you, and I will move a motion. I so move a motion.
Before you move the motion, member from Easton, are you relying on 831 or 832?
Madam
different.
Speaker, it's both. It's 83-2, a motion to disallow a member's vote on the grounds of personal pecuniary may be moved only as soon as the member or members voting on the question. But 83-1 is amendments relating to matters in which he has a direct pecuniary interest or speak on any matter, whether in the House or in committee. And this is an amendment. This is not a bill, bill to make a law.
Member, continue reading so that the House can have the full position.
Without disclosing the nature of that interest, and shall in no circumstances vote on any such matter.
So for the benefit of the chair, you are relying on 831?
That is correct, Madam Speaker. In this instance.
So basically, the point at issue is whether or not there's a direct pecuniary interest. Can you confirm, member from Easton?
Yes, Madam Speaker.
Okay.
And if I may, because it was a little broken, the 831 when I spoke on it, if you wish, I can read that, Madam Speaker, in its entirety without break.
Please do so.
Madam Speaker, 831 says, 1, a member shall not move any motion or amendment relating to a matter in which he has a direct pecuniary interest or speak on any such matter, whether in the House or in any committee, without disclosing the nature of that interest, and shall in no circumstances vote on any such matter. Madam Speaker, I have not seen any declaration of such matters. Thus, I'm bringing it before the legislative, the members of this honorable House and your good self to make a determination on.
Honorable Minister responsible for financial services, the chairs would just ask you one basic question. Do you have a direct pecuniary interest as far as you're aware of?
Thank you, Madam Speaker. Madam Speaker, I take my responsibilities in this honorable House very seriously. And while the members on the opposition side have been discussing this issue for some time publicly, most of the time has been spent casting aspersions and making allegations about conflicts of interest in relation to myself and others on this very important issue of this legal practitioners bill that we've been trying to get dealt with for 15 years, Madam Speaker. Madam Speaker, because I take my responsibilities seriously and because of those allegations being made, I have taken specific legal advice from senior counsel on any relevant circumstance in my situation or relevant to myself, including, Madam Speaker, the matters which the member has mentioned. And I have been advised, Madam Speaker, that I do not have a direct pecuniary interest in relation to this matter which I need to declare to this honorable House. Madam Speaker, such is my concern about ensuring that my principles are reflected in my behavior and that I do the right thing. Madam Speaker, you will know that I have provided you with an explanation and a clear indication of the advice which I was given and the fact that that advice says that I have no direct pecuniary interest to declare. I think, Madam Speaker, that enables me to continue with this presentation of this bill, Madam Speaker. Madam Speaker, I regard it as unfortunate that we are now in a position where the members have taken this issue of the presentation of the legal practitioners bill to a new low, which has nothing to do with the merits or demerits of the bill, nothing to do with a discussion or analysis of the issues, but simply an attempt to smear any and everybody who could be involved. Yes, Madam Speaker, I am a former partner of one of the law firms. That experience and my knowledge, Madam Speaker, made me or put me in a good position to fulfill the role that I perform as Minister of Financial Services. The allegation is that because of that, I am somehow conflicted, or I am somehow in contravention of Standing Order 83. Madam Speaker, I think that I have done what I need to do personally. I have done the right thing. I have done the responsible thing, and I've taken senior counsel's advice on this issue, Madam Speaker, which advice has been that I do not have an interest which requires me to declare it in accordance with Section 83 or Standing Order 83, and an interest which precludes me from being able to speak, present this bill, and to vote on it, Madam Speaker. Thank you.
Member from Easton.
Thank you, Madam Speaker. Madam Speaker, the minister says he takes his responsibility seriously. So do I. I have an absolute responsibility to ensure there's no conflict in this House. And that is why I'm standing on my feet, Madam Speaker. Because it is in the better interest of the country and its people that no one in here has a conflict, and when they do, they don't speak. That's my responsibility too. Thank you very much. Madam Speaker, legal opinions, they don't work in here. Oh no. Unless it's matters dealing with this House and the Attorney General opine on them. You can get as much legal opinion as you want outside. It's the members who decide whether or not there is a conflict. There's no court decides in here. And an opinion, you can get as many of them as you want. And everyone is going to be different. So this has nothing to do with getting Queen's counsel. That may satisfy his mind, Madam Speaker, but that doesn't say it satisfies the requirements that the members of this honorable House sees as a conflict. It absolutely does not. And everybody should take note of that. Madam Speaker, as a matter of fact, that minister happens to be the chairman of the Register of Interest Committee and has never had a meeting in 4 years. Madam Speaker, I submit, Madam Speaker, that the minister has a conflict because of his position with regards to walkers, past, present, or future. I further submit, Madam Speaker, that the Attorney General is the constitutionally right person to bring this bill.
Honorable Attorney General, are you able to shed any further light on this issue as it relates to Standing Order 83?
Thank you, Madam Speaker. Although briefly to say, usually, certain as members of our profession, if there is a conflict, we are the ones who usually best determine whether or not we're conflicted. It is part of our training. It is. It has always been. And that's why when lawyers have matters referred to them, they do what is called a conflict check to determine whether or not there is any conflict in certain circumstances. The Honorable Minister has made it quite clear that he has gone the extra mile to seek external opinion, which is always a commendable thing to do, because even though sometimes we are convinced in our minds, it is always advisable to have another view, another opinion, which he has done. And Madam Speaker, if he's satisfied, having received that opinion, that he's not conflicted, then clearly it's a matter for him. And of course, if it gets to the stage where he makes further disclosure and the motion is moved in this House, then clearly it's a matter for the House to decide. But it is not unusual for an attorney to seek a legal opinion just to satisfy him or herself about the issue of whether or not there is conflicts.
Thank you. Member from Easton, did you have something to add?
Yes, Madam Speaker. And Madam Speaker, I'm trying to find the provision in the Constitution under which that the Attorney General falls. His functions, and I'm having difficulties going through it to find it. Attorney General 56. Let me get me a little specs here. Madam Speaker, let me see that before I read that the Attorney General say that lawyers are best to determine whether or not they got conflict. Oh yeah? Really? Even preachers are human beings? I wonder if the gentleman in Jamaica recently determined that taking people money and using it, he determined that that was not a conflict.
Member from Easton, let's keep it relevant. You're on Section 56 of the Constitution.
Thank you, Madam Speaker. Madam Speaker, Section 56. There shall be an Attorney General of the Cayman Islands, whose office shall be a public office, and who shall be appointed in accordance with Section 106. The Attorney General shall be the principal legal advisor to the government and the Legislative Assembly. Now, Madam Speaker, if the membership would wish, I can go and read how he's appointed, 106. But for the purposes of this exercise, that's not needed. I do not need that, because what I'm about to say, I move that the Attorney General advise this legislature as to whether or not, investigating and advise this legislature as to whether or not the Minister for Financial Services has a conflict of interest.
Honorable Attorney General, I thought that's what you just attempted to clarify. Did I miss something?
I am not so sure what he's asking me to investigate and advise the House.
Madam,
That's what he's saying.
Madam Speaker, the Attorney General, when called upon by your good self for some degree of clarity. He said that lawyers are best suited to determine if they conflict. Madam Speaker, I submit that that's not necessarily so. One, there is evidence. The Minister for Financial Services said he consulted Queen Counsel. So he really not, or unless he considers himself incapable of doing it. Madam Speaker, 56(2) says, the Attorney General shall be the principal legal advisor to the government and the Legislative Assembly. Now, my submission is that we ask the Attorney General to advise this Honorable House on whether or not the Minister for Financial Services has a conflict. To do such, the Attorney General would have to research. That's all I'm asking for.
But member from Easton, the Honorable Minister for Financial Services, when called upon by the chair, and obviously this is an honorable house and the respect is due for the chair, and he knows the consequences of not, with being non-economical with the truth. I have no reason to believe that he did not speak the truth when I asked him, do you have a direct pecuniary interest? And he answered in the negative with that. That's why I asked you whether it was Standing Order 831, because the Liptus test for Standing Order 831 is of such that it must be a direct pecuniary interest, not a pecuniary interest. It's slightly different under 2 because there's a timing element which can only be moved at the time of the vote, and we're just at the commencement, or we're attempting to get to the commencement of the discussion of the second reading of the bill. I then solicited a response from the Honorable Attorney General, just for my own clarification. So at this, I've listened to what you said, and at this stage, unless there can be some submission of direct evidence that the member still has an equity, he's still an equity partner, there's some direct relationship or that's there, the chair would have no other alternative to find that I do not find a direct pecuniary interest. At the best case scenario, they could be an indirect, because he is a landlord, from what has been submitted even by your good self, member from Easton. I have not heard any evidence being submitted that he's anything else but that. So unless I can hear that, the chair would rule that I do not find that there's a direct pecuniary interest. If at any stage during the debate that comes to light from either side of the House, then obviously the chair will have to reconsider and the standing order set out procedure to be followed. But at this stage, I have not heard or have not seen anything to prove to me that the Honorable Minister for Financial Services has a direct, and direct is the operative word in this case. Honorable Leader of the Opposition.
Madam Speaker, I don't know if I should at this point, but perhaps we ought to look at Mays, Erskine Mays, and the 24th edition, and page 80, which talks about the declaration of interest and debate. And, Madam Speaker, I am not in any way going against what you have just said, but I thought, for the sake of clarity, that we should examine what Mays is saying, and perhaps you want to take 5 minutes. And I certainly like to be absolutely clear in my mind where we're going with it.
The onus is on the member that's speaking, Honorable Leader of the Opposition, that if he or she has such an interest, the onus is on that person to declare that there's an interest. And obviously, if they don't, and it's proven to the chair that there's an interest, there are sanctions that can be taken. I did call upon the Honorable Minister for Financial Services, and he stood He was not under oath, but he stood there as an honorable member, as I take all members of this House to be until it's proved to the contrary, and said that he did not have a pecuniary interest. No other member has been forthcoming and proven that there is a direct pecuniary interest. And I did give members opportunity, and I still give members opportunity. I recognize the Honorable Attorney General, who's now on his feet.
Thank you, Madam Chair. Let me just reiterate, Madam Speaker, sorry. The honorable member is under an obligation, honorable minister rather, is under an obligation to examine and declare whether he has an interest. He, according to him, has done so. Not only has he done so, he has taken the additional step of seeking advice from learned Queen's Counsel, who has also confirmed that he's not conflicted in any way that requires any disclosure to this honorable House. Madam Speaker, and
yes,
thank you. And unless the honorable member from East End has evidence to the contrary, then it certainly is a matter for the honorable member and for yourself, Madam Speaker. We take him his word. His word is his bond. But I would have thought that if he has gone, taking the other precaution to get a legal opinion from the Queen's Counsel, that to me is as best as you could have hoped for in the circumstances. So I think, notwithstanding the concerns of the member from North Side, from East End, sorry, and I'm not for one questioning whether or not his belief is genuinely held. But the fact is that there is an opinion to the contrary. And I think at least we ought to respect the Honourable Minister's position as it relates to that. He's not just a minister of this House, but he's also a member of the legal profession, which also places a particular onus on him. He's a member of the legal profession, which puts an added burden on him to ensure that his conduct in those circumstances are certainly consistent with the ethics of the profession. Thank you.
Madam Chair.
Member from Eastern will take a final intervention and then we'll move on.
Madam Speaker, I should then bring us all to the attention of Standing Orders 88.2. Wherein 88.1 and 2, wherein if there is doubt, we need to refer to the rules of House of Great Britain and Northern Ireland, which is Erskine May. But
where is the doubt?
Well, Madam Speaker, obviously there is doubt here as to whether or not, because he has learned counsel, doesn't erase the doubt that the members have, and we are entitled, any member is entitled to bring the motion.
But you can only bring a motion, member, if you're bringing a motion under 83.2, you'll bring it when the vote is taken. That's why I asked you at the beginning, honourable member, whether you were relying on 83.1 or 2, and you specifically said 83.1, and that's the direction of your argument thus far.
Madam,
yes, please.
I thank you. Madam Speaker, what I'm saying, when there is doubt on the standing orders, then, Madam Speaker, maybe since I'm not the lawyer, the Premier can say what, in any matter, not herein provided for, resort shall be had to the usage and practice of the Commons House of Parliament of Great Britain and Northern Ireland, which shall be followed as far as the same may be applicable to this House, and not inconsistent with these standing orders, nor with the practice of this House. In cases of doubt, the standing order that this House shall be interpreted in the light of the relevant usage and practice of the House of Commons. But no restrictions which the House of Commons has introduced by standing orders after the making of those orders shall be deemed to extend to this House or its members until the House has, by standing order, provided for such restriction. Since I'm no lawyer, someone interpret that then. But, Madam Speaker, the Attorney General got up here and said that the Minister for
Financial Services.
Financial Services is a member of the legal fraternity. No such thing. He announced on radio that he has not kept up his registration.
Member from Easton, we, through
Madam Speaker, if I may, I shall bow to whatever your ruling is. The question has
I
been
was just
put.
responding to the point that you raised about our deference to MACE, and that's made when our standing orders is incomplete or is silent in a procedural matter. And in this case, our standing orders does in fact have a section dealing with pecuniary and professional interest, and there's the sections which you quite adequately relied on, 82, 1, 2, 3, and 4. And from my reading and from my cognizance, I do not see where it is silent on it. It sets out very specifically how the matter should be dealt with if it's a pecuniary and professional interest. And the chair has not found that there's a direct pecuniary interest.
Madam Chair, Madam Speaker, I was referring to that section 88 and May as there is nothing on indirect pecuniary interest. And if it is silent, like you say, on indirect, then you refer to me.
But remember from Easton, the fact that it actually says, it didn't just say pecuniary interest. And I'm sure our forefathers and mothers were brilliant enough and had the foresight enough when they chose the words, because the English language is very precise. And shall I reflect and remind members, it says a member shall not, which means it's mandatory, move any motion or amendment relating to a matter in which he has a direct pecuniary interest. So there's a conditioned precedent. And I'm sure the movers and the drafters of this would not have included the word direct if they wanted to lower the bar to be that just merely of a pecuniary interest. If we, in 2017, is not satisfied based on progress or lack thereof that it should be direct, then I would say that members make a move to delete it through the correct procedure so that Standing Order 83 would read that has a pecuniary interest. At that stage, we would have the opportunity to say what direct and indirect is, or refer to May standing orders, which if you look at May standing orders, it does cover circumstances of direct and indirect. It is the view of the chair that we do not have to refer to Mays because our standing orders said specifically it must be a direct pecuniary interest.
And so if it's not direct?
And it's not direct.
But then that's why you ought to go to Mays. Because it's not...
Honourable Leader of the Opposition, and after that we'll move on.
Madam Speaker, I know that, and I don't have any intention to tax your patience or otherwise, but perhaps we should read the section of Mays, if you permit, that deals with direct and indirect, because while our standing orders relate to direct pecuniary interests, Mays talks about the indirect aspect. And Mays, in page 80 of the 24th edition, if you allow, declaration of interest in debate, and it says in debate, a member is required to declare any relevant pecuniary interest or benefit of whatever nature, whether direct or indirect, that he may have had, may have, or may be expecting to have. Thus, the rule relating to the declaration of interest is broader in scope than the rules of relating to registration and requiring the declaration of both relevant past interests and relevant interests which the member may be expecting to have in the future. Members are also encouraged to declare non-registrable interests, which might be thought to influence them. Such interests have been held to include financial interests which fall below the registrable threshold, financial interests of close family members, and any other circumstance which, though exempt from the requirement to register, might be thought to have a bearing on a member's personal financial position. And it goes on to say that it is the responsibility of the member, having regard to the rules of the House, to judge whether a financial interest is sufficiently relevant to require declaration. The basic test of relevance is similar to that for registration, that a financial interest should be declared if it might be reasonably be thought by others to influence the member's speech. Where, however, a particular interest was shared by members at large, in this case as employers of staff, the Speaker ruled that the members should be expected to indicate a relevant interest only where that was plainly additional to their interests as members of the House. A declaration should be brief, but should make specific reference to the nature of the member's interest. A member should declare such an interest when it is most relevant to do so, normally at the beginning of his or her remarks. Any declaration should be sufficiently informative to enable a listener to understand the nature of the member's pecuniary interests without recourse to the register or other publications. I think that I thought should be put on the record.
Honorable Attorney General.
Madam Speaker, I just want to confirm, the Honorable Leader of the Opposition read that it is within the judgment of the member to make that determination?
It's the responsibility of the member.
Thank you.
Same thing.
But there are other things that I thought is not clear enough.
Honorable Minister for Financial Services. The bill has been duly moved. Does the Honorable Mover wish to speak to the bill?
Yes, thank you, Madam Speaker.
Honorable Minister, let me just say, so that everybody will be on the same footing, that interjection dealt with 83.1. Standing orders still obviously have a scope for 83.2. And until we get to that stage, I have no control whether another member or members may wish to deal with it at that stage.
Yes, Madam Speaker.
I'll then
Thank you.
move from there.
I certainly clearly understand that, Madam Speaker. And I haven't heard anything which changes my assessment of whether I have a direct pecuniary interest that I'm required to disclose and recuse myself under Standing Order 83. I've taken advice on it, not because I had doubt about it, but because I knew that this was going to be an issue that was raised with the other side intending to make an issue of it and play politics about it. Madam Speaker, moving on to the presentation of the bill. Madam Speaker, I am seeking today to defy the odds which have prevented for many years the critically important modernization of the law relating to the regulation and governance of the practice of Cayman Islands law. The bill, Madam Speaker, which I am to present on behalf of this government is a bill which, by repealing and replacing the Legal Practitioners Law 2015 revision, seeks to create a modern platform to regulate the practice of Cayman Islands law. For the first time, Madam Speaker, wherever it is practiced, in a way which meets international standards and provides mechanisms which seeks to redress these long-standing concerns that have existed in Caymanian practitioners relating to fair opportunities for training and development, Madam Speaker, and promotion. Madam Speaker, other than that, let me say up front that the bill reflects proposals which do not seek to make significant policy changes in terms of how the practice of law has been successfully carried out to the benefit of the country to date. Because, Madam Speaker, it is one of the fundamental and core underlying professions of our financial services industry. The fact that we have not been able to achieve modernization of the law relating to the governance and regulation of this industry for more than 15 years now that we've been trying has been to the detriment of the country. And I will get on to outline, Madam Speaker, the various important issues and imperatives which are driving the need to have this bill passed and this new modern form of regulation and supervision of the practice of law in the Cayman Islands. So, Madam Speaker, just very broadly now, there are three broad imperatives for this bill. The first is the need for the bill to create a modern platform to regulate the practice of Cayman Islands law and its practitioners in full compliance with the current international standards, particularly relating to the anti-money laundering and the countering of financing of terrorism provisions which are promulgated under the Financial Action Task Force standards and recommendations. I've already reminded this Honourable House, Madam Speaker, in some detail of the upcoming assessment later this year by the Caribbean Financial Action Task Force, which seeks to ascertain both compliance with technical requirements as well as a demonstration of effectiveness of the regime in meeting the objectives of the AML CFT regime. Madam Speaker, a satisfactory rating coming out of that assessment is absolutely necessary for this jurisdiction to maintain its positive reputation as a well-regulated jurisdiction and a sophisticated place in which to do business. Not addressing the known or identified areas of deficiency, Madam Speaker, in respect of international standards, it's simply not an option for us as a country which relies so heavily on the financial services industry and the contribution to it, the contribution to our economy, our job market, and the direct revenues, Madam Speaker, of the Cayman Islands government. The legal profession, Madam Speaker, in conjunction with the accounting profession, seems to be popularly viewed these days in some international circles as potential enablers or facilitators of transactions, and therefore there are higher risks of falling foul of the AML-CFT regime. So, Madam Speaker, the Financial Action Task Force has set out in its recommendations specific proposals which address the regulation of lawyers as well as accountants as a part of the general business referred to as designated non-financial businesses. And these are perceived, Madam Speaker, to carry greater risk and therefore are in need of specific regulation. Madam Speaker, members of this Honourable House will recall that we recently considered and passed a new accountants law, 2016, to regulate the public accounting profession by way of a very similar framework that is proposed in this legal practitioners bill. And that framework and that law was done in part to achieve the same end for the same reasons. Some of the major differences, Madam Speaker, is that while the same approach of a single private sector regulator and disciplinary body as in the accountants law is replicated in this bill, because of the real or perceived need to address issues around the training and development and promotion of Caymanian lawyers, there are a specific number of provisions, or a number of specific provisions, Madam Speaker, in this bill, which seeks to address those issues, and I will talk in more detail about those a bit later. Madam Speaker, I know that most, if not all, of the opposition members supported the accountants bill at the time that enables that profession to have the necessary regulatory framework in place to satisfy the assessment standards. And I hope they can appreciate that given the legal profession, that the legal profession is at least equally in need of this, it is critically important that we have the new regulatory framework that's proposed in this bill in place to similarly regulate the legal profession in accordance with international standards and to achieve, very importantly, Madam Speaker, a satisfactory assessment coming out of the Caribbean Financial Action Task Force assessment later this year. Madam Speaker, the second imperative for this bill is one that is long-standing and many of us are familiar with. It is similarly a critical need to modernize the legislation which regulates the legal profession of the Cayman Islands and the practice of Cayman Islands law wherever it is occurring, Madam Speaker. Madam Speaker, the Legal Practitioners Law 2015 revision was originally passed in 1969 at a time when there was probably less than 30 people practicing Cayman Islands law. And I say people rather than lawyers deliberately, Madam Speaker, because a number of those practitioners were in fact what were described back then as law agents. They did not have formal training or professional certifications, which we have today. They were often self-taught, but very capable people in society who filled a need at that time. Now, of course, Madam Speaker, the need at that time was primarily related to domestic issues, family law, basic contracts, wills and estates, and so forth. While at that point, Madam Speaker, there was perhaps some rough idea or rough vision of what the Cayman Islands might become as a leading international financial center that it is today, I very much doubt that the extent or the significance of our role and the size of our profession and the complexity of the practice of Cayman Islands law as it exists today and the global reach and significance of these three little islands of our small country in the Western Caribbean, Madam Speaker, could have been foreseen. So, Madam Speaker, it is that the current law, even though amended over the period of time since it was brought into or was passed in 1969, it simply cannot cope and has glaring gaps and lacunas in respect of the regulation of the practice of law with the current realities today and the task of overall regulating this complex, vibrant, sophisticated, and thoroughly modern practice of Cayman Islands law that we have now. Madam Speaker, I have heard members say in the past weeks and months that, well, it's not true that the legislation wasn't amended since 1969. That is absolutely true. It has had amendments. It has had lots of minor little amendments. It is still 16 pages, Madam Speaker. It still does not reflect the realities that we have before us today, reflecting the current practice of Cayman Islands law. And it certainly does not in any way address some of the current concerns and long-standing concerns that Caymanian lawyers have had around the questions of training, development, and promotion. This bill, Madam Speaker, seeks to address some of these issues, Madam Speaker. Now, Madam Speaker, focusing on the geographic reach, the issue that has exercised much of the debate in the context of modernization of the legal practitioners law has been the reality that the practice of Cayman Islands law is now carried on to a significant extent outside the Cayman Islands. Madam Speaker, we now have Cayman Islands law being practiced in most of the centers of commerce around the world. Now, having said that, Madam Speaker, I should point out that we are not unique in that respect. All of our major competitors are doing the same thing and taking the same approach, Madam Speaker. And Madam Speaker, it is absolutely true to say that this practice initially arose in terms of a Cayman context as much as a defensive or reactive approach to the actions of our competitors as it was a response to the pull of globalization and the pursuit of opportunity. So, Madam Speaker, we were far from being the first jurisdiction amongst our peers to have overseas offices for law firms. Nevertheless, Madam Speaker, there has been a view expressed in some quarters for as long as we've been seeking to modernize the practice of, or modernize our legislation, that the practice of law outside the Cayman Islands is disadvantageous to Cayman and to the interests of Caymanian practitioners. That is a view that some reflect. Madam Speaker, I think it is largely this view which has effectively stymied efforts at modernization at this point. Madam Speaker, I think around 2008, we had roughly about 100 lawyers who were practicing Cayman Islands law in offices overseas. Today, that number is closer to around 200 by my estimates. Madam Speaker, that, whatever people want to call that, is a reality that all of our competitors have been engaged in, and all of them have been trying to address the need to deal with proper regulation and a way to control this and a way to ensure that it is developing in a way which both benefits the country, both ensures that the financial services industry is strong and growing as a result of that, but also addresses the local concerns. Madam Speaker, what is a little ironic is that these concerns arise specifically because the existing law has absolutely no provisions dealing with the current practice of Cayman Islands law as it exists today in its full reality, and preventing the modernization of the existing law, Madam Speaker, only serves to exacerbate the concerns that have been expressed to begin with. It is also ironic, Madam Speaker, that it is those who have been fighting against modernization to reflect the current realities and to address the current realities have been doing so against the Caymanian Bar Association itself, who have been leading this issue for the better part, well, let's say leading this issue for nearly 15 years now. We have other members on the other side of the House who have been engaged in that very same process during that period of time.
Madam Speaker, on a point of order.
Please state your point of order, member.
Madam Speaker, the minister is saying that there are members on this other side of the House who has been engaged in trying to prevent modernization of the legal practitioners bill. That's not true. He needs to say who it is that is on the side engaged in such behavior.
Honorable Minister for Financial Services, if you're in possession of specific members and have your proof, then you can proceed along that line. Otherwise, I'm going to ask you to take a detour and get back on track.
Madam Speaker, I think and I apologize if it came out wrong, but I think the member misunderstood what I was saying. I was simply saying that the Caymanian Bar Association has been involved in the charge to try to get the modernization of the legal practitioners law. And I'm saying that certain members of this House, let's say certain members of this House have been, on both sides, have been involved in this process through the Caymanian Bar Association. I thought that that's what I was saying. If I didn't say that, then I apologize.
Madam Speaker, now...
Member from Easton, do you have a point of order?
Madam Speaker, the members now being economical with the truth on his words, which is that he said there are members over on this side who have been engaged in trying to stop it. Now he's saying that we have been on the side of the CBA, we're trying to get it through. That's not what I rose on a point of order. He is saying things about the members on this side that that is not a fact, and he needs to declare and name those people.
Honorable Minister for Financial Services, are you in position to identify the members? And if not, then please don't generalize.
Madam Speaker, as I indicated earlier, I thought that I was saying that there are people who have been pushing against the modernization, and that there have been people as members of the Caymanian Bar Association who have been engaged in the process of trying to help address this issue. And some members, the fifth elected member from Georgetown was a member of the Caymanian Bar Association, as well as myself and other members. So I'm simply saying that there are certain members who have been a part of this, Madam Speaker, but to the extent that the members feel that I was suggesting that there are members on that side who are not in favor of it, that wasn't what I was suggesting at this point, Madam Speaker.
Honorable fifth
So I
elected member
withdraw it.
from Georgetown.
Madam Speaker, on a point of order, that's exactly what the member said. There are members, what he started out saying is there are members fighting against modernization, and then went on to say that there was at least one member on the side involved with the process. It's the first bit that I take umbrage to, because I've never said I'm against modernization of this bill. I've always said that you need modernization, but it has to be with balance, and the Caymanian situation has to be improved. That's what I'm fighting for.
Honorable Minister of Financial Services.
Madam Speaker, if I said members initially, in terms of the first limb, as a member from Georgetown has indicated, then I certainly withdraw that. I wasn't suggesting that.
Okay, let's move on.
So, Madam Speaker, the Bar Association's concerns were based on the perceived reputational risks posed to the jurisdiction because the existing law, Madam Speaker, provides no framework for any form of regulation for the practice of law overseas. And secondly, because of concerns of dislocation of the economic value and reduced opportunities for Caymanian practitioners. Madam Speaker, the issue of the practice of Cayman law overseas is therefore an important issue, which this bill seeks to address, Madam Speaker, by providing, firstly, for the issue of practicing certificates to lawyers in overseas offices, for the same qualification requirements to be applied across the board, irrespective of geographic location, for a mechanism through which those practicing Cayman Islands law overseas have a definite nexus and connection to Cayman, and for a mechanism in the form of a one-to-one ratio which limits the number of non-Caymanian lawyers of any one firm that can receive practicing certificates to work overseas, so, Madam Speaker, that the aggregate of all non-Caymanians working for a particular firm overseas cannot exceed the aggregate of all lawyers and trainees working in the Cayman office of that firm. Madam Speaker, there is a proposed an amendment to the relevant provision which would, for the purposes of the ratio, restrict the number of non-Caymanian lawyers in the Cayman office only to those who have been in the islands for a minimum of 1 year. Madam Speaker, representations were made during the public consultation process that perhaps firms could hire people quickly and get them into their offices and grow the numbers locally in order to create capacity offshore to hire more. Hence the reason for the proposal to restrict it to only those non-Caymanian lawyers in Cayman who have been here for at least 1 year. Madam Speaker, it's fair to say that our experience with the overseas offices of Cayman firms in a protracted period spanning several decades now is that fears of rampant growth outside of Cayman have not materialized because overseas offices will operate in high-cost centers, high operating costs, and high tax in particular scenarios. And, Madam Speaker, firms pursue rational decision-making and only growing to the extent of the opportunity they think is available in that location or region. But this mechanism, Madam Speaker, certainly puts this ratio, one-to-one ratio, Madam Speaker, certainly puts a limit on that, irrespective of what the realities are in terms of how firms approach it. So, Madam Speaker, one of the long-standing arguments has been that law firms have overseas lawyers with offices to stack them, or overseas offices with lawyers to stack them because it's cheaper than Cayman, and it allows them to circumvent the immigration requirements. If that was correct, Madam Speaker, and based on the evidence, I would agree that it is a real concern, that we should try to find a way to address it. But is it true, Madam Speaker? Madam Speaker, I think if it was true, we should be able to look at offices around different parts of the world and see evidence of that very thing happening. Madam Speaker, the jurisdiction in which Cayman firms operate that is closest to Cayman in terms of costs and no income tax would really only be the Dubai International Financial Center. That is similar in cost, perhaps a little more in operating costs, but it is tax-free. Madam Speaker, if the speculation is true about firms willing to or wanting to place many lawyers overseas to avoid Cayman regulation and Cayman costs, then we would see it there. Madam Speaker, I have looked at the websites for 2 Cayman firms that I know of that have had offices in the DIFC for the last, since 2005, so close to a dozen years ago. One of them, Madam Speaker, has 6 lawyers based on the website, and the other one has 9. Now, Madam Speaker, I recall well those offices when I last visited there in Dubai, probably about 8 years ago. And they were very much similar in number at that time. So, Madam Speaker, I think based on what I have seen, the reality doesn't really match the speculation. And I think that should be able to satisfy the arguments that this is not a driving force behind the motivations of firms. They are there to service the needs of clients. But we do have other scenarios happening, Madam Speaker, where we have firms that have no connection to Cayman, no nexus to Cayman, no office in Cayman, and they have people who are practicing, who we believe are practicing Cayman Islands law. And we have a law which is deficient in its ability to deal with it. Madam Speaker, I think it's helpful just to provide some background in terms of the rationale for the practice of Cayman Islands law overseas. The primary driver for this, Madam Speaker, is meeting client expectations. Now, there was the initial response from a Cayman context was a defensive measure against competition. I think another one of our competitor jurisdictions opened an office overseas. In the Asian region, which Cayman eventually responded to. But the bottom line, Madam Speaker, is that where we have centers of commerce and there is a need for the type of sophisticated, high-quality international financial center services, products that we have, clients will go with those options that are available to them who are in their time zone and in their geographic location generally. So when we talk about meeting clients' expectations, Madam Speaker, this is precisely the thing we're talking about. If we're not there meeting their expectations, in those centers of commerce, if we're not there to be able to go to their office, visit them, or have them come to our office to discuss transactions or to have closing meetings or to have meetings with other onshore counsel, we are going to lose business because they have options, Madam Speaker. And if we're not there and those expectations are not met, clients will simply look to an alternative jurisdiction. And unfortunately, Madam Speaker, there are many other jurisdictions today who are strong competitors. Madam Speaker, we are not the only choice. We do not get to dictate the rules of global finance and the needs of, and the demands and the wants and the desires of sophisticated customers. The polar opposites reflected there. Madam Speaker, the truth is the gap has narrowed in terms of competitive advantage for Cayman. Many jurisdictions that compete with us, Madam Speaker, have improved their services, they've copied our policies and products, and they're generally much better than they were in the past. So we have got to find a way to continue to differentiate ourselves. We've got to find a way to continue to innovate, to create cutting-edge products, and to deliver services that are second to none in order to continue to maintain what we once had, which was a lot of clear blue water. We still have some of that, but it's a lot less. Madam Speaker, this is just another way of saying we must not just meet client expectations, but we must differentiate ourselves by exceeding those expectations whenever possible. The third broad imperative, Madam Speaker, and one which is of significant importance to all of us, is the concern or the concerns expressed by Caymanians in relation to perceived limitations in training, in the development and promotion opportunities within firms. This is a general complaint that we hear, Madam Speaker, and it's probably because of the numbers most often in relation to larger firms where there's greater competition. In particular, Madam Speaker, is the perception that too few Caymanians have made it to the top as equity partners in one of the big firms. Madam Speaker, it's a fact that the large firms are certainly making the largest share of investment in the scholarship and training of Caymanians to qualification. I have been advised, based on review, that it is also the case that close to 90% of Caymanians trained to admission by their training firms have been retained by them. The rate of attrition, Madam Speaker, does increase by the time those kept on initially are in the region of 3 years post-qualification experience. And that is reflected, Madam Speaker, in a drop in the retention rate to something around 65%. But Madam Speaker, if we compare those numbers to other regions, to the UK, for example, and other Commonwealth territories, Madam Speaker, those are not bad numbers. But we would certainly love to have them better. I did 10 times more than any of you. Madam Speaker, the pace of qualification for Caymanian lawyers is not slowing down. We currently have 21 article clerks in training in Cayman, and since 2008, we've had 114 lawyers who have completed their training to admission here. In total, Madam Speaker, the Cayman Bar Association has around, I'm told, 130 student members. These numbers, Madam Speaker, suggest that the penetration of Caymanian lawyers in the local profession is increasing substantially. In fact, Madam Speaker, of the 700 plus lawyers that I understand are enrolled today, around 240 of those are Caymanian. Whatever the number is, Madam Speaker, it is very clear that that number is set to continue to grow significantly. While we absolutely, Madam Speaker, have to have a level playing field and an environment which enables our fellow Caymanians to achieve their full potential, at the same time, Madam Speaker, we must be careful to ensure that, as is the case with other industries in Cayman, firms do have access to the numbers of skilled and experienced staff that they may need to operate effectively. Madam Speaker, this bill seeks to work in conjunction with and seeks to enhance the applicable provisions of the immigration law to ensure that there is this appropriate balance achieved which serves the interests of Caymanians in the legal profession and serves the interests of the legal profession in ensuring that it is effective and continues to work well. Madam Speaker, we are, as Caymanians, we are very proud people. We all want to accomplish all that we can, and we want our children to be able to do the same. It should be the case that based on our abilities, we should be able to maximize our potential. And if we're capable of participating in ownership and management of law firms, then those opportunities should be available to us. Madam Speaker, some of us have had those opportunities. There are a good many others, Madam Speaker, who are well on their way, if not there at this point. Notwithstanding this, Madam Speaker, there is this perception that not enough of us have had these opportunities. And that must be addressed. Madam Speaker, it's not hard to feel that reality. But I think, Madam Speaker, this bill finally goes a long ways to addressing concerns around these issues and puts in place mechanisms through which Caymanians may become a part of this very significant legal fraternity and have the opportunity to develop, be trained, and progress to any level they want to achieve. Madam Speaker, I said environment and framework deliberately, Madam Speaker, because that's what it needs to be. We don't need a mechanism which gives Caymanians anything, because I know that there are many young Caymanians out there. There are many other Caymanians who are in the profession currently, who are at varying levels, who got there on their own merit. And we simply need a framework which provides that platform for them to do that. They don't need to be handed anything. They don't need a mechanism which mandates that a certain number of people must be partners, or mandates that at a certain point they must become partners. We are proud people, we are capable people, and we will continue to be capable people, and we will continue to demonstrate that we can do that. There, as I've said here before, Madam Speaker, there is a crop of young lawyers in this country today who are amazing in terms of their abilities and their qualifications. And we will not see those Caymanians failing to achieve their full potential. I am confident of that, Madam Speaker, but this law, this bill, provides a framework through which this can happen, and we address all of the plethora of issues that have existed for some time. Madam Speaker, as I said, this bill seeks to create this supportive environment. It does so in several ways. Including, Madam Speaker, making it an express function of the council of what will be created by this, of the regulatory body, legal body that will be created by this bill, called the Cayman Islands Legal Practitioners Association, making it an express function of that to promote the qualification, training, and development of Caymanians as attorneys at law. Madam Speaker, the bill also creates a special business plan regime applicable to any law firm that has just one work permit holder. And it also provides, Madam Speaker, for the mandatory application of best practice guidelines which firms have to apply and follow where they have provided an acceptable explanation, where they have provided an acceptable explanation why it is difficult for that particular firm to follow the best practice guidelines which are set out in the bill. These guidelines, Madam Speaker, are based on those published by the International Bar Association. Madam Speaker, in terms of the first imperative and the relevant parts of the bill, I would note that Part 1 of the bill includes definitions that are used throughout the bill, and Part 2 of the bill deals with the creation of this Cayman Islands Legal Practitioners Association. This is a corporate body, Madam Speaker, with separate legal personality and run by a council. So I'm going to provide some of the detail around the issues and the provisions of the bill which are constructed to address some of these issues. Madam Speaker, SILPA will be the body which is the regulator of those practicing Cayman Islands law anywhere in the world. And in order to achieve this, Madam Speaker, the bill provides in Clause 24 that no one can practice Cayman Islands law in the islands or in any other jurisdiction other than in accordance with the provisions of Part 4 of the bill. Madam Speaker, they have to be an attorney at law as defined in Clause 2 of the bill. And that effectively means they will have to have a practicing certificate and have their names on the court roll. In that case, Madam Speaker, pursuant to Clause 5 of the bill, all such attorneys at law are required to be members of SILPA. Part 2, Madam Speaker, goes on to clarify that members of SILPA are only liable for unpaid membership fees if it was ever wound up. that in each year the council may or must call a meeting of the members and provide a report from the president detailing the business carried out by the council in the previous year, considerations of audited accounts and the election of a new council. Madam Speaker, I note here that the bill currently contemplates an annual election, but we are proposing an amendment so that the election would, in fact, be biennial, because the composition of the council is fairly complex by design to try to ensure that it is very much representative of the various interests, and that in particular is a specific comment received from small firm practitioners who want to ensure that their specific interests are represented by members of their specific component of the membership of SILPA. There are other relevant provisions, Madam Speaker, dealing with typical matters for an association, such as how meetings are requisitioned, who presides at meetings of SILPA, and the duties of the secretary. So, Madam Speaker, the first thing the bill achieves is this creation of this singular body which will regulate the profession and ensure that practitioners are complying with their obligations under the law. The body will also deal with complaints from the public and address disciplinary measures if thought appropriate. Part 3 of the bill, Madam Speaker, deals with the composition and powers and functions of the council to enable SILPA to function and perform its regulatory role. Now, Madam Speaker, I'll talk a bit more subsequently about the specifics of the council, but suffice it to say at this point that this regulatory body will be required, pursuant to Clause 79 of Part 9, to receive annual reports or annually from law firms, a report which certifies that during the previous year the firm complied with each of the obligations imposed on it by the provisions of the bill, the misuse of drugs law 2014 revision, the proceeds of crime law 2014 revision, and the terrorism law 2015 revision. In my subsequent comments, Madam Speaker, I'll note in more detail the requirements in Part 6 of the bill to comply with the mandatory code of conduct. But for the present discussion, Madam Speaker, I will note that that Chapter 5 of the Code enshrines the obligations of each practitioner to observe and comply with regulations made under the misuse of drugs law, the proceeds of crime law, and the terrorism law, and they're also required to follow any relevant supervisory or regulatory guidance made by the Cayman Islands Monetary Authority or the Legal Advisory Council, which will continue under this bill. Also, Madam Speaker, a firm of attorneys must maintain appropriate records and carry out appropriate procedures in accordance with such regulations for the conduct of relevant financial business. The express incorporation of these obligations, Madam Speaker, is absolutely crucial to the impending 2017 or later this year CFATF assessment, as we have discussed. And Madam Speaker, the reality is, if Cayman does not have the Legal Practitioners Bill 2016 in place, and it has to produce the Legal Practitioners Law 2015 revision to the CFATF assessor, we are guaranteed to fail the assessment. That will not be a good result at all for the Cayman Islands, for this, or for our financial services industry, and for those Caymanians who depend on a strong financial services industry to serve the needs of the country. Madam Speaker, so coming back to the need for modernization of the law to regulate the legal profession as a second imperative noted above, we have touched on parts 1 and 2 of the bill, and continuing with that, I note that part 3 of the bill provides details around the Council of the Association. Clause 11 to 23 of the bill, Madam Speaker, sets out matters which includes the composition of the council, the method and details around the election of the council, the general responsibilities of the council, rules around meetings of the council, quorum requirements, and rules as to how to deal with conflicts and declarations of interest. It further provides a requirement for the council to keep accounts, a power for the council to charge a membership fee and the rules around that, a power of the council to appoint committees, and lastly, powers of council to make general rules as well as rules of procedure for itself and rules relating to financial matters that law firms should be complying with. Madam Speaker, the council will have powers clearly that are not insignificant. After all, it is going to be the regulatory body. There are a number of powers and functions of the council which have a direct impact on attorneys at law. There's also, Madam Speaker, one specific function to note, and that is in clause 13 to E, which has been noted earlier, is the function to promote the qualification, training, and development of Caymanians as attorneys at law. Madam Speaker, the foregoing comments which I have set out explains why the government, with the support of the Caymanian Bar Association, wished to have the composition of the council arranged in a way that the majority perspectives and experiences represented would be those of Caymanians and smaller firm attorneys. So, Madam Speaker, Clause 11.1 provides that the council will consist of 8 members who are attorneys at law, and Clause 11.3 provides that they must all be resident in the islands and at least 5 of the 8 must be Caymanian, which is defined in the bill as being in accordance with Section 2 of the immigration law. So, Madam Speaker, we have a majority of the members of the council who are Caymanians. Madam Speaker, the desire to ensure that we have as broad a local Caymanian perspective as possible doesn't just stop with that provision. Madam Speaker, we also, through the same Clause 5, will be requiring that 3 out of the 5 Caymanian members must have achieved their qualifications locally so that they are able to provide that local perspective in the operations and functions of this council. Madam Speaker, in pursuit of relevant perspectives to ensure that we include all those in the decision-making process, Clause 11.3 further states that at least 2 of the members of council must be attorneys from firms with less than 10 attorneys. This reflects this desire, Madam Speaker, to ensure that the perspectives of small firms are represented on council by 2 members. That is a minimum, Madam Speaker, I should emphasize. It's not a maximum, it's a minimum. So we could end up with more small firm representation. But, Madam Speaker, one of the committee stage amendments that will be proposed in respect of this bill is specifically in relation to how the 2 required small firm representatives are elected. Part of the comments received in respect of the consultation, Madam Speaker, was that small firms did not feel that the broader body of the membership of SILPA would be able to appropriately elect representatives on their behalf to reflect their true interests. So there is this proposed change which will seek, Madam Speaker, to allow those firms which are 5 members or less to separately appoint, or elect rather, their own 2 representatives to council, and it is only if they fail to do that that the broader membership would appoint them.
Honourable Minister, we've reached the hour of interruption. I'd like to recognize the Honourable Premier.
Thank you, Madam Speaker. Madam Speaker, I beg to move the suspension of Standing Order 10.2 in order that the business of the House may continue beyond the hour of interruption.
The question is that Standing Order 10.2 be suspended to allow the business of the House to continue beyond the hour of interruption. All those in favour, please say aye. Against, no.
No.
I believe the ayes have it. Accordingly, Standing Order 10.2 is hereby suspended. Please continue with your debate, Honourable Minister for Financial Services.
Thank you, Madam Speaker. Could I get an indication of the remaining time?
At 4:37, you'll have 1 hour remaining.
So, Madam Speaker, I've explained the appointment for representatives of small firms and the change that we propose in respect to that and why. There is also, Madam Speaker, a proposed limit of 2, no more than 2 members from any one firm, because there is a concern that a bigger firm could end up dominating the membership of the council. And this, the council, with the powers that it has, both from the perspective of the power that it has to ensure that the right things are done and good things are done, as well as, Madam Speaker, ensuring that the interests of Caymanians are properly fulfilled in accordance with their powers. All of that is best served by having as broad a representation on council as possible, and not something which is narrow in terms of where these membership, the membership comes from. And that, Madam Speaker, that has been certainly the subject of a lot of comment. And I think that approach addresses, or should address, those concerns. Madam Speaker, because of those concerns, Madam Speaker, we, in a general sense, we have taken the time to review all of the comments and views from all of those who have provided input to understand what their concerns were and to ensure that they were appropriately addressed. Madam Speaker, there is a particular issue that I would like to raise or deal with in terms of comment, which has been the subject of concern as well, which has been in relation to the clause 23 relating to the power of council to make financial rules. That clause, Madam Speaker, is essentially about the requirements and possible rules to protect client monies, which may be maintained by law firms, and in particular, how to keep client monies separate from the monies of the firm. Madam Speaker, the particular clause which has been attracting comment is 23.2, and that provides that the council may make rules prescribing how such client accounts shall be audited. Madam Speaker, it is very clear to me that this is a suggestion of rules which may provide for an audit only of a client account and not the financial statements of a firm. But there have been concerns expressed and unfortunate conclusions drawn that it means that the council could prescribe a mandatory audit for small firms. I certainly do not wish any member of the legal profession or owner of or operator of a small firm to be under that view, Madam Speaker. And I certainly wouldn't be supporting anything in the way of a mandatory audit. So, Madam Speaker, there will be a committee stage amendment specifically to ensure that it is clear that this is specifically in relation to the question of whether the conduct of client monies are being appropriately dealt with. But, Madam Speaker, it will be necessary to ensure that SILPA, in appropriate circumstances where there is a complaint, for example, can or does have the power to call for a specific audit of those client accounts. But again, it is not the normal operating accounts of any practice. Madam Speaker, moving on, I mentioned previously that Part 4 of the bill deals with the practice of Cayman Islands law, and Clause 24 in particular goes beyond the current law by specifically providing that the bill would regulate the practice of Cayman law, not just within the islands, Madam Speaker, but in the rest of the world as well. The contravention of which, Madam Speaker, can result in a fine of up to $100,000 and incarceration for up to 2 years. Madam Speaker, in addition to that, because the current law does not adequately define what it means to practice Cayman Islands law, Clause 24 very clearly does so. And importantly, Madam Speaker, it also prescribes activities which are routinely carried out by other service providers, by individual members of the public on behalf of themselves or public officers, which, importantly, from a policy perspective, Madam Speaker, should not be taken as practicing Cayman Islands law. There are things which the public should be able to do for themselves, which do not require them to go and hire an attorney to do, Madam Speaker. Madam Speaker, Clause 24.5 would give Cabinet the power to make, well, provides currently, it would give Cabinet the power to, in consultation with the Council of SILPA, to make an order making changes to Clause 24. Madam Speaker, there would be a committee stage amendment in respect to that, which seeks to provide that it is cabinet only that makes that decision in terms of an order, and it does not require, it will not require consultation with the council. Madam Speaker, this obviously is for speed and convenience. Madam Speaker, I beg your indulgence for one moment. Thank you, Madam Speaker. Madam Speaker, Clause 25 goes on to provide that attorneys who hold a Cayman practicing certificate may practice Cayman law in the islands, but also outside the islands as well, provided that they comply with the provisions of the bill relating thereto. And importantly, Madam Speaker, they must also comply with the laws of the jurisdiction in which they are practicing Cayman law. Part 4, Madam Speaker, also goes on to exclude the functions of the Attorney General and the Director of Public Prosecutions from being affected in any way, including their respective chambers and office, or anyone they instruct to assist them. Madam Speaker, Part 5 of the bill deals with admission as an attorney, and much of the provisions are similar in principle to the current law, with some important clarifications and additional provisions. This part, Madam Speaker, makes clear what a judge who's considering an application for admission must be satisfied on, in addition to being satisfied that the applicant is a fit and proper person to be an attorney. Now, one of the important personal qualifications in the bill, Madam Speaker, is that if an applicant is not ordinarily resident in the islands, but is instead so in another jurisdiction, he must be a partner, director, member, or an associate or employee of a qualified firm or an affiliate of a qualified firm. And Madam Speaker, this concept of a qualified firm or an affiliate of a qualified firm, this concept is a critical part of the framework which supports the issue of practicing certificates to attorneys who reside outside the Cayman Islands and wish to practice Cayman Islands law. Madam Speaker, we are certainly aware, as noted earlier, that of strong allegations that certain firms overseas have been taking advantage of the fact that our current law is silent on the issue and trying to design a framework which enable those who are currently practicing Cayman Islands law to enable them to continue to do so, albeit with Cayman Islands practicing certificates. We needed to ensure that this was limited to those attorneys and firms which have a connection or a nexus to the Cayman Islands. And we successfully exclude those, Madam Speaker, who do not have that nexus or connection. In addition, Madam Speaker, we needed a way to ensure that the decisions in overseas offices relating to the practice of Cayman law were not being made or dominated by partners from other jurisdictions who are a part of the group who may have conflicting views or biases in favor of their own or other jurisdictions over the views of the Cayman-based or overseas-based partners running the Cayman practice. So effectively, we needed a mechanism which gave the Cayman-based partners and those running overseas practices of Cayman firms full control over the practice of Cayman law within their firms. And this is particularly important, Madam Speaker, in firms where the Cayman office is in fact a branch of a firm which is headquartered elsewhere. So, Madam Speaker, after consideration, this mechanism of qualified firms and affiliates and their overseas affiliates was agreed upon to achieve this policy objective. And this is to ensure, Madam Speaker, that there is this nexus and that the decisions which are being made reflect those decisions which are most beneficial to our economy, to our country, and to the interests of our Caymanian lawyers. They're not new concepts, Madam Speaker, that have been created specifically in terms of this bill. They, I think, date back as far as the 2009 version of the bill that was developed by the Bar Association, which was supported at that time. And I should add, Madam Speaker, that the whole concept of having a nexus or requiring a nexus or a connection for firms which have offices overseas, that is reflected as well in recommendations of the Law Reform Commission from as far back as 2007. And if I have time, Madam Speaker, I will run through some of those. So broadly, Madam Speaker, the mechanism contemplates that to be able to get practicing certificates for lawyers in overseas offices, they have to work for affiliates of a qualified firm. So the first prerequisite is that the firm must fall within the definition of a qualified firm. And that is intended to be a firm in the islands in respect of which the voting control is held by persons who are resident in the islands and who are Caymanian or have at least one Caymanian partner amongst their number. An affiliate of a qualified firm must have similar voting control in Caymanians or other residents in Cayman, in respect of which there is at least this one Caymanian partner amongst their number. And further, Madam Speaker, those persons must have a right of veto over the promotion and appointment of any attorney in either the qualified firm or any affiliate of the qualified firm. So those partners that are Cayman-based need to have overriding control over who becomes a partner in an overseas office to practice Cayman Islands law, and not perhaps other partners in the same group or a related group who otherwise have some voting control. So this framework is created to protect the interests of the Cayman Islands, protect this nexus and control, and protect the interests of Caymanians. Madam Speaker, as it is with the current law, at the moment the bill does not require any special qualification in respect to a new firm being established in the Cayman Islands, which is not intended to be a qualified firm with any affiliate. That will be subject to the normal licensing and work permit process as it is today. But we needed this mechanism to ensure that where a firm was talking about having overseas offices, that's when that mechanism came into play and protected the interests of the jurisdiction. Madam Speaker, we are proposing an amendment which will, in those circumstances, let me start over there, Madam Speaker. Madam Speaker, significantly, Clause 34 of Part 5 of the bill would, for the first time, seek to codify in law the existing policy that an applicant for admission to the bar in Cayman needs to have at least 3 years PQE. For many years now, Madam Speaker, that has been a policy position which is implemented through the actions of the Honourable Attorney General. This will codify this 3-year PQE in law, Madam Speaker, but the bill also provides, further provides, that after the 1st of January 2019, this minimum PQE will increase to 4 years. In addition, Madam Speaker, there will be a requirement from commencement of this bill that each applicant will have to complete 4 months or have completed 4 months of many articles and have taken an exam set by the Legal Advisory Council, which is designed to address concerns expressed that lawyers who are seeking to be admitted to practice in Cayman should have demonstrated some minimum familiarity at the time with Cayman Islands law. In respect of the, Madam Speaker, in addition, let me note that Clause 35 of Part 5 ensures that all persons admitted to practicing Cayman Islands law must make an application in accordance with the rules of the court, which means, Madam Speaker, effectively that they have to appear in person. The judge has to be able to look them in the eye and consider their application and move or accede to their admission. The transition provisions, Madam Speaker, in Schedule 1 to the bill provides that they will have 12 months to accomplish this. But as I said, all lawyers in overseas affiliates will be required to travel to the Cayman Islands to accomplish this. And I should say, Madam Speaker, there's a proposed committee stage amendment which will effectively reduce this to 9 months and require that existing lawyers indicate within 90 days of commencement of the bill that they wish to be admitted and obtain a practicing certificate, and that they have the necessary qualifications. Having complied with that requirement during that minimum period, Madam Speaker, they would have a further 9 months within which they could seek to complete their admission process. So, Madam Speaker, moving on to Part 6 of the bill, this part deals with the status of attorneys and the high standards of professional ethics and conduct to be observed, amongst other things. Of particular significance, Madam Speaker, is Clause 38.4, which makes it mandatory for attorneys and law companies to observe the Code of Professional Conduct set out in Part 1 of Schedule 2 to the bill, and for law firms themselves to observe the law firm's best practice guidelines set out in Part 2 of Schedule 2 to the bill, which I will speak about in a bit in more detail. Madam Speaker, the background significance to the Code of Conduct is that under the rules in the UK at the moment, a lawyer who is Cayman qualified is unable to take advantage of the qualified lawyer transfer test mechanism to be able to get admission or seek admission in the United Kingdom, because, Madam Speaker, we do not have a mandatory code of conduct in place. This bill, Madam Speaker, will address this concern or this issue by having the necessary provisions and attaching the bill to the code of conduct to the schedule, which will be mandatory on the legal profession. So that will open up that opportunity for qualification, Madam Speaker, through the current equivalent of the qualified lawyer transfer test. Turning to Part 7 of the bill, Madam Speaker, this will vitally provide further that it is an offense to practice Cayman Islands law outside the islands without being in possession of a valid practicing certificate. Part 8 of the bill, Madam Speaker, deals with law companies, and Part 9 deals with law firms. The two are the typical forms of business organizations through which the practice of law is carried out. Madam Speaker, for law companies, the managers and shareholders must be attorneys, and there is a mandatory insurance requirement because they are limited liability companies. There is no mandatory requirement for insurance, Madam Speaker, in respect of partnerships because all partners are jointly and severally liable for debts of the partnership. Madam Speaker, a very important provision of Part 9 is Clause 68, which is representative in part of the third imperative which I talked about previously. This clause, Madam Speaker, seeks to put a limit on the number of attorneys that can have Cayman Islands practicing certificates outside the islands relative to those within. The clause, Madam Speaker, provides a very important ratio which may not be exceeded by a qualified firm, and I've talked about that, and its affiliates. I've talked about that in some detail earlier, but the ratio is described, Madam Speaker, as A must not exceed B plus C plus D, where A is the number of non-Caymanian attorneys who practice outside of Cayman, B is the number of Caymanian lawyers who practice with a qualified firm or any of its affiliates anywhere, and C is the number of non-Caymanian attorneys who practice with the qualified firm inside Cayman, and D equals the number of trainee attorneys employed by the qualified firm and any affiliates. I mentioned the committee stage amendment change in respect of C, Madam Speaker, such that it would be the number of non-Caymanian attorneys who practice with the qualified firm in Cayman who have been in Cayman for at least 1 year. That ratio, Madam Speaker, is designed to ensure that if the Cayman firm is growing, there is capacity to grow offshore and meet the needs of clients. But it can't be the other way around. The offshore offices cannot be growing and getting larger with more lawyers than we have centered in the Cayman office, which will include our trainee attorneys, because that is an incentive for firms to continue to do what I think they've been doing, at least the bigger firms, and doing a fairly good job with. But of course, those are the firms with the resources to do a much better job, and those are the ones we certainly expect to see continue that. Just to clarify as well, Madam Speaker, in terms of the Caymanian attorneys in B, that they can be anywhere in the world. So I talked about the offices of two firms that are in the Dubai International Financial Center. Madam Speaker, one firm there has 9 attorneys. One of those attorneys is actually a Caymanian. There are a number of other offices, Madam Speaker, that I know of where our own Caymanians are working and doing admirable jobs and are quite happy. So, Madam Speaker, this is effectively a 1-to-1 ratio where a qualified firm in Cayman has or can have the aggregate of all of its overseas offices, have in the aggregate all of its overseas offices, no more attorneys than they have on work permit within the island, and Caymanian lawyers anywhere, plus their trainees. So this caps the numbers of non-Caymanians that can be outside of Cayman. Madam Speaker, the managers of a qualified firm are also responsible for ensuring compliance with this ratio. And they're required to file a certificate by January 31st in each year, certifying their ratio numbers. Madam Speaker, Clause 69 gives the clerk of the court the power to enforce this if there is a breach by suspending the practicing certificates of those non-Caymanians in overseas offices sufficient to bring the firm back into compliance with the ratio. Now, obviously, Madam Speaker, that would be viewed as a harsh remedy, but it shows the seriousness with which this provision is viewed. Madam Speaker, moving on to Part 10, dealing with business staffing plans.
Minister, you have 37 minutes remaining.
Thank you, Madam Speaker. Madam Speaker, this Part 10, dealing with business plans, is another crucial part of this bill, which seeks to address the concerns of Caymanians. Clause 73, Madam Speaker, provides that any firm which seeks to apply for any work permit or which seeks to obtain a practicing certificate for an attorney practicing Cayman law overseas with any affiliate must submit a business staffing plan to the board. So the current regime, Madam Speaker, is if you have, I think it's, you have to have about 15 work permits before you have a requirement to file a business staffing plan. In this case, the business staffing plan requirement would kick in the moment you seek to apply for any work permit for the firm. This is obviously, Madam Speaker, a special regime which is far more stringent than the normal business staffing plan requirements, and they will have significant power to strengthen the provisions if it is perceived to be necessary at some point in the future. Madam Speaker, the managers of a firm are obliged to ensure that the firm is in compliance with their business staffing plan, and if they are in breach, not only might it constitute professional misconduct, which might found a complaint under Clause 95 of the bill, Madam Speaker, but it may also be an offence under the immigration law 2015 revision, which may subject the manager to penalties under that law as well. Neither of those scenarios reflect consequences, Madam Speaker, which a manager will want to subject themselves to. Madam Speaker, Clause 76 of the bill articulates the purpose of the bill, of the business staffing plan, which is to ensure that firms accept a commitment to provide opportunities to Caymanians. And specifically, Madam Speaker, a business staffing plan is designed to make reasonable provision to give Caymanians access to the legal profession, including training and development and subsequent equitable progression within the law firm. Further, Madam Speaker, a business staffing plan must contain details of how the firm intends to comply with the provisions of the guidelines set out in Part 2 of Schedule 2. Those guidelines, Madam Speaker, seek to improve transparency in firms around a variety of areas, including training and development, performance management, remuneration and benefits, career development, amongst others. Being aware, Madam Speaker, of what is expected of them, the opportunities that are open to them, and what they have to do in order to achieve progression is the minimum information, Madam Speaker, that Caymanian employees should be clear on as a result of this. So, Madam Speaker, this is yet another important aspect of this bill which is in the interests of Caymanians. Madam Speaker, there are two further protective provisions. Firstly, the business staffing plan must contain a provision that if an attorney is proposed as a partner and the board refuses to approve a work permit in that position, that person will not be able to get a practicing certificate as a partner in an affiliate or overseas office for a period of 2 years. And secondly, Madam Speaker, a firm may not appoint a person or promote a Caymanian as a partner, a non-Caymanian as a partner, without first providing to the Business Staffing Plan Board a declaration regarding the effect of such appointment or promotion on the opportunity for advancement for any similarly qualified Caymanians. Madam Speaker, there is an amendment proposed which will add specifically that the Business Staffing Plan Board must also, in addition to that declaration being made, the board must also give approval before any promotion is carried out. So they have full ability to consider the full ramifications and whether it would be appropriate to approve such a promotion for a non-Caymanian. Madam Speaker, remaining parts of the bill consist of Part 11 dealing with local education qualifications and Part 12 dealing with articles, which together has similar provisions to the current law. And Madam Speaker, an important point to note is that those doing articles under the new regime proposed by this bill will specifically be able to do so in affiliates' offices, and that, Madam Speaker, offers significantly greater opportunities and advantages of exposure to new cultures and the direct business world and specific client exposure and the daily rigors of the practice of law while dealing with the clients directly, Madam Speaker. So, Madam Speaker, to date, I think around about 50 Caymanian lawyers and trainees have had the opportunity to work in overseas offices, and having this mechanism under this bill will only facilitate greater opportunities for Caymanian article clerks to be able to work in the overseas offices and get good training at the same time. Madam Speaker, that will certainly only enhance opportunities for Caymanian lawyers. Madam Speaker, Part 13 deals with the very important provisions of the bill dealing with the investigation of allegations of professional misconduct, and Part 14 deals with final provisions which relate largely to the practice of the laws of other jurisdictions within the Cayman Islands, which may be done with the consent of the Council. So if someone is in the Cayman Islands, not practicing Cayman Islands law, but giving advice on the laws of foreign jurisdictions, they may do so with the consent of the Council. Part 14, Madam Speaker, also contains the repeal provision for the current law and gives effect to the transition provisions in Schedule 1. Before leaving this, Madam Speaker, I want to note in respect of Part 13 that it makes provision, amongst other things, for the appointment of a professional conduct committee and a disciplinary tribunal. And of course, Madam Speaker, this reflects, the composition of these two committees reflect the Caymanian-centric theme, which is reflected in the Council of the Association. Madam Speaker, those two bodies, the Professional Conduct Committee and the Disciplinary Tribunal, will effectively have a majority of their members being Caymanians. Specifically, Madam Speaker, Clause 94 empowers the Council to, after their election, to appoint a 5-member Professional Conduct Committee. So it will comprise of 2 members of Council, 2 attorneys who are not on Council, and a person approved by the Attorney General who has professional qualifications but who is not an attorney. So that provides an outside perspective. Madam Speaker, it further provides that at least 3 of the 5 members of the PCC shall be Caymanian. And similarly, Madam Speaker, Clause 98 provides that the Chief Justice shall, on receiving a complaint of misconduct, which the Professional Conduct Committee were unable to resolve, appoint a disciplinary tribunal, which will consist of the Chief Justice and 2 attorneys or former attorneys nominated by the council, and at least one of whom shall be Caymanian. So 2 of those members will be Caymanian, and therefore there'll be a Caymanian dominance on that tribunal, Madam Speaker. Madam Speaker, it is also significant that the bill will provide a proper disciplinary process for the first time to address allegations of misconduct, and the disciplinary tribunal will have full powers of court to resolve matters, including being able to order that an offending attorney may be struck off the court roll or fined up to $100,000 amongst other powers. Madam Speaker, Madam Speaker, I think we should address a few issues that need to be put to rest. The bill reflects, Madam Speaker, some on the, well, as members of this House will probably understand by now, know by now, reflects a joint position paper, which was finally agreed between the Caymanian Bar Association and the Law Society. And it is patently obvious that the provisions set out in the bill, Madam Speaker, reflect a very Caymanian-centric position and a framework which puts Caymanian perspectives first. This bill, Madam Speaker, is based on this joint position as modified by government. The specific provision which government included, Madam Speaker, firstly was the ratio in Clause 68, so that there could be no growth outside unless there was matching growth within the islands. And also that would incentivize the hiring of more Caymanian lawyers, as well as article clerks. Madam Speaker, secondly, we require that all firms, whether qualified or whether they're qualified firms or affiliates of qualified firms, had to have these business staffing plans. And lastly, we required that the law firm's best practice guidelines be included, Madam Speaker. And of course, I'm happy to indicate that those were specifically sourced by the 5th elected member from Georgetown when he was on the government side, Madam Speaker, from the International Bar Association website. Madam Speaker, the bill was drafted following the issuance of drafting instructions by Cabinet based on the foregoing, and it was certainly a clean slate approach which was carried out by an external draft person, Madam Speaker, who had previously worked for the Cayman Islands government. I can assure anyone, Madam Speaker, that the bill was certainly not drafted by any individuals at the Caymanian Bar Association or at the Cayman Islands Law Society or any member firms thereof. The Cayman Islands Legal Drafting Office finalized the initial draft and have subsequently been involved in refinements, Madam Speaker, and they will be finalizing the committee stage amendments. Madam Speaker, there has also been a number of comments that this bill seeks to put an undue burden on small firms or sole practitioners. Madam Speaker, nothing is further from the truth. This government, Madam Speaker, has stated emphatically and delivered on its promise that we would not be increasing taxes or fees generally. And in fact, the opposite is true, Madam Speaker. We have significantly reduced fees in a number of ways. And certainly in relation to this bill, Madam Speaker, we were careful to ensure that this was reflected there. Madam Speaker, as a reminder, there is no operational license fee on small firms or firms of 5 lawyers or less. There is no mandatory insurance unless you choose to operate as a limited liability company. A limited liability law company, sorry, specifically, a limited liability law company. And there is no mandatory insurance. In fact, Madam Speaker, this bill is drafted in terms of the transition provisions in Schedule 1, that the fees as they exist under the current law and regulations will exist under the bill as a law. So there was no contemplation of any mechanism to increase the level of fees or change them initially. Madam Speaker, furthermore, the bill proposes significant opportunities for involvement by small firms in the council. And that, Madam Speaker, is only limited by their willingness to participate. It is therefore untrue, Madam Speaker, to suggest at all that there's any disadvantage to small firms under this bill. Madam Speaker, notwithstanding that fact, we are also proposing further committee stage amendments which will further reduce the cost to sole practitioners and small firms and make the operating burden paid by firms more fair and ensure that it applies to all lawyers that work in qualified firms or their affiliates in the Cayman Islands. So, Madam Speaker, we'll be seeking to change the way the operating license fee is calculated. And that will do a number of things, Madam Speaker. We are removing any disincentive to take on a Caymanian lawyer or the opportunity to grow for firms where their numbers are currently just short of the next band within the existing fee band structure. And this is going to be particularly beneficial for firms, small firms who are looking to grow beyond 5 lawyers. At the moment, if they take on the 6th lawyer, they would fall within the first fee band under the operating license regime, and they would pay something close to $20,000 in fees. The committee stage amendments that we're proposing would reduce that effectively to just under $4,000. This provides a fairer mechanism and a better opportunity to grow for small firms, but it is also fair for all firms, Madam Speaker. So for all the talk and concern about the impact on this legislation, on the aspirations of Caymanian lawyers, Madam Speaker, it has to be clear that the negative impact on the interests of Caymanian lawyers is not what is contained in this bill, Madam Speaker. It is not this bill, but it is the absence of a bill like this being passed and implemented. That is what is patently against the interests of Caymanian lawyers, but not just those, the jurisdiction and the country as a whole. Madam Speaker, it cannot be more clear that going from a position where there are no restrictions or controls on the practice of Cayman law overseas to one which seeks to have carefully constructed controls and restrictions which address core qualifications, minimum PQE, competency initiatives, and a mechanism to limit speculative growth outside the jurisdiction. That must all be better Madam Speaker, and must better serve the interests of Caymanian lawyers and the jurisdiction. There are certainly those who will continue to feel, Madam Speaker, that, as they have in the past, that preventing this bill will be some sort of victory. Madam Speaker, I would describe that as a Pyrrhic victory. Madam Speaker, the current status quo is the worst possible situation for the country and the interests of Caymanian lawyers. Every day that goes by, Madam Speaker, without the provisions of this bill, we slip further behind our competitors in terms of modern regulation, and the interests of Caymanians suffer further. Any success, Madam Speaker, at delaying this bill is, as I have said, not a victory for anyone. It will be a defeat for the interests of our Caymanians and Cayman as a whole. Madam
Minister,
Speaker,
you have 17 minutes remaining.
yes, thank you, Madam Speaker. Madam Speaker, you know, there's another point which I would address, and it's in a way personal. I have certainly had the good fortune to have people in my life who saw potential when I didn't, and urged me to pursue a career in law. And one man in particular, Madam Speaker, that I will always be grateful to is Mr. William Walker, who was my principal. He and his partners, Madam Speaker, at the time encouraged and gave me an opportunity to become a lawyer when I thought I had no interest in the profession. I was always a science-oriented person, Madam Speaker, someone who was in awe of the beauty and wonders of our God-given natural world, and enamored with the complex science and chemistry, biology, and physics that governs our world and the universe. Madam Speaker, I thought I would be connected to that in some way, but I have certainly grown to love the law, grew to love the law, and I worked hard for many years and was lucky enough to go from being an article clerk to retiring as global chairman of a Cayman headquartered firm, a firm which is a substantial organization with a significant global presence, Madam Speaker. And the thing that I am most proud of is the opportunities that it provides for many Caymanians. Madam Speaker, no one can tell me in the history of my experience about what it's like to have to deal with politics in the office, what it's like to have to deal with discrimination sometimes, and difficulties with dealing with certain people. So I understand when people experience those types of things today, Madam Speaker. But you have to work through that, and I would encourage our fellow Caymanians who come across these things from time to time not to give up, but to continue and to fight, to continue to chase their dreams and achieve their full potential, Madam Speaker. Madam Speaker, I have certainly tried my best during my career. I have to help my fellow Caymanians, as many as I could, and today, that is one of the motivators for me to be in this office, to be here today as the minister presenting this bill to try to get a new regime in place after all this time of fighting and arguing and having this particular issue, Madam Speaker, be a political football. Madam Speaker, that is my motivation for being here as the minister doing this job. And I think, Madam Speaker, I can confirm I should confirm that I am not here representing any organization. No, I have no interest in the private sector. I have no ownership interest. I long ago retired and walked away from that, Madam Speaker. Madam Speaker, I have mentioned this in detail because there are those certainly who will question motives and make allegations of conflicts rather than really looking at the merits and demerits of the provisions of the bill. Madam Speaker, these are the same types of issues that have prevented this bill from being implemented in the past 15 years, or any similar bill from being implemented in the past 15 years, Madam Speaker. And it is amazing that sometimes it seems that there's a view that this is a one-shot deal and there will be never another opportunity to further enhance any legislation in respect to this. Clearly, Madam Speaker, that is not accurate. We all know that much of the things, in fact, much of the agenda here today, Madam Speaker, is not bespoke new bills, but amendments to existing bills. So there will always be this opportunity, as long as there are Caymanians who sit in these seats, Madam Speaker, in this honourable House, there will always be the opportunity to assess whether there's a further amendment or evolution of a concept or principle or a mechanism which is needed to further serve the best interests of our fellow Caymanians and this jurisdiction and this very critically important financial services industry in which this profession operates. Madam Speaker. Madam Speaker, I think it is time for this legislative assembly to seize this opportunity and finally pass this essential bill. Madam Speaker, I want to just very quickly reiterate a summary of the benefits which this bill provides or provides for. Madam Speaker, firstly, we have the protective provisions to keep control of the practice of Cayman Islands law with Caymanian attorneys and non-Caymanian attorneys, which are largely based within the Cayman Islands. This reflects recommendations in terms of nexus and connection, which was reflected in a report from the Law Reform Commission back in 2007, Madam Speaker. We talked about the Council of SILPA must consist of 8 attorneys, 5 of whom are Caymanians. So there's a Caymanian dominance. We talked about the Council having responsibility to promote the qualification, training, and development of Caymanian attorneys, or Caymanians as attorneys. Madam Speaker, we talked about ensuring that non-Caymanian persons seeking admission with a foreign qualification will be suitably qualified to practice Cayman Islands law. We talked, Madam Speaker, about the compelling law firms to comply with strict business staffing plans, much more strict than what exists currently under the provisions, the relevant provisions of the immigration and law and regulations, including, Madam Speaker, provisions to ensure that qualified Caymanian attorneys are properly considered for promotion inside and outside of Cayman, which strengthens the career opportunities for Caymanians. Madam Speaker, we also talked about a protective provision to set a limit on the number of trainee attorneys an attorney may. So I didn't go into that, but there is a protective provision in the bill, Madam Speaker, which sets a limit on the number of trainee attorneys that an attorney may take on. So again, an attorney simply can't take on a number of article clerks and thereby create capacity for either more work permits locally or more work permits externally. There will be a limit clearly on how many they can adequately train. Madam Speaker, I mentioned the various committee stage amendments that we are proposing as I went through. I think all of those, Madam Speaker, add very substantively to the very positive impact of this bill in terms of creating a framework which provides a very critical framework which provides for the effective regulation and control of the practice of law as it exists in the context of the Cayman Islands and our significance in the global financial services industry today, Madam Speaker. Madam Speaker, I would like to, before closing, Madam Speaker, take the opportunity to thank, Madam Speaker, the many members of the Caymanian Bar Association, as well as the...
You have 7 minutes to do so.
Yes, Madam Speaker, thank you. Thank the many members of the Caymanian Bar Association, as well as the Cayman Islands Law Society, Madam Speaker, who have contributed so much time and effort to this initiative over the years. And this bill in particular, Madam Speaker, on which those two associations have, as of the context of doing this bill now, finally reached agreement. Madam Speaker, for 15 years, there was disagreement between the Caymanian Bar Association and the Cayman Islands Law Society on issues relevant to this. So it is understandable that in years past, with those different perspectives and issues, it is understandable that it was more difficult to get a bill which genuinely reflected the majority interests and concerns. Madam Speaker, today we have a bill which is based on a joint position of the Cayman Islands Bar Association and the Law Society. A bill which reflects a lot of principles and a sea change movement between the Law Society and the Bar Association. But by that I mean the Law Society moving more towards the position of the Bar Association, the perspectives of the Cayman Islands Bar Association, and seeking to reflect those interests in the law, and jointly seeking to ensure that we have a piece of legislation which best protects this jurisdiction, which best protects the reputation of this jurisdiction, which best protects the opportunities for Caymanians today and in the future in this jurisdiction who are seeking to pursue careers in this most honorable profession, Madam Speaker. So I want to thank them very much for the various movements and positions that they have taken, which have allowed this to happen, finally, Madam Speaker. And I don't want to forget that certainly the Law Society has demonstrated that the vast majority of their membership, something around 90 or 95%, are in support of this bill. The Caymanian Bar Association have indicated that their membership by majority has supported this bill, Madam Speaker. Madam Speaker, they did a survey amongst their membership where they asked one simple question, and that was, are you in favor of this bill, or do you support this bill, or do you not support this bill? They supported the bill as was published, Madam Speaker. The amendments even add a far greater basis upon which the members of the Caymanian Bar Association can support this bill, Madam Speaker. And I am happy to say that the members of the Cayman Islands Law Society have been right there in agreeing to those amendments, which better underpin opportunities for Caymanian lawyers, Madam Speaker. So, Madam Speaker, I also want to thank the judiciary and specifically Chief Justice Smelly for some helpful contributions that he certainly made and his colleagues made in terms of just giving an overall perspective on whether the framework looked appropriate. but also in respect of certain specific committee stage amendments, which deal specifically with the admission of partners on a limited admission basis, or not partners, overseas lawyers coming into the Cayman Islands on a limited admission basis, Madam Speaker, because we seek to protect the ability for those members, whether they're senior members of the local bar or junior members, to have a sustainable path for development at that bar. And I'll talk more about that during the committee stage amendments, Madam Speaker. So I certainly would like to thank them, the Honourable Attorney General, certainly, Madam Speaker, colleagues, and our Honourable Premier. Certainly not least, Madam Speaker, I want to thank the consultant draftsperson, the Government Legal Drafting Department, for their patience and good work, as well, Madam Speaker, as the excellent members of my ministry. And I, without trying to diminish the input of others, I certainly would single out the Senior Policy Advisor, Andre Ebanks, himself a lawyer who has been very tolerant, Madam Speaker, of my pressures to get things done for the benefit of this country and for responding without grumbling.
You have 2 minutes remaining.
So Madam Speaker, this concludes my presentation on this very critically important bill. Madam Speaker, I think given the fact that it is as controversial in some areas or some quarters as it is, I think that is probably one of the best indicators, Madam Speaker, of how critical it is to get a bill like this in place, which addresses the concerns and issues of Caymanians and the needs of the jurisdiction for proper regulation of this profession. Madam Speaker, I thank you very much, and I will simply say that I commend this bill to the members of this Honourable House for passage. Thank you.
I recognize Honourable Premier.
Thank you, Madam Speaker. Madam Speaker, given the indication of members from the other side that they would not be prepared to go ahead with debate this evening, I'm proposing to adjourn and return to the bill, debate on the bill tomorrow. And so, Madam Speaker, with your permission, I would move a motion that the relevant standing order be suspended in order that government business may take precedence over private members' business tomorrow, Thursday, and that the order paper for tomorrow can be prepared on that basis.
Recognize Honourable Member from Easton.
Thank you, Madam Speaker. Madam Speaker, what I am hearing here is the government is again utilizing their power in here to truncate the opposition with private, which is a day set aside for opposition private members' motion, or for that matter, backbench private members' motion. Madam Speaker, the government cannot continue to truncate the opposition by doing these things. They don't answer questions for us. They put 2 questions on the order paper this morning which had to be postponed. It is curtailing the ability of the opposition members to function in this Honourable House. Madam Speaker, I respect that there are times when the government must get things through. I respect the old cliche that the government will have its way, but it also says that the opposition should have its say. So, Madam Speaker, I'm prevailing upon your good self in the chair, who is the presiding officer, to look at this with a clear view of the deliberate attempt this government is making to try to curtail or truncate the opposition in getting their job done. It is wrong. The same way the government has business, the opposition has business to be conducted in this honorable house. And because they have the majority, they are deliberately doing it, Madam Speaker. And I prevail upon your good judgment as the presiding officer.
Madam Speaker,
Honorable Premier.
I'm not inclined at all to get into an argument. I just want to bring some practicality to the members' comments. We have, looking at the diary, 12 working days left before the House is dissolved. There are 23 more bills, 3 government motions, not counting the committee stage amendments. The members have indicated they have more than 120 proposed amendments to this bill alone. There are 10 private members' motions. And so, Madam Speaker, unless we make some real progress, most of the business of this House, a lot of the business of this House is simply going to fall away without being dealt with. Madam Speaker, we are not proposing to prevent the opposition from presenting their motions. I've indicated, and I've spoken to the leader of the opposition, that we will give back the day, the Thursday, that they lose tomorrow, providing we have the time towards the end of the meeting in order that the opposition gets their 1 day a week. But if we don't press on, and indeed I'm indicating to members that we are going to have to start sitting much later than 7 o'clock, starting tomorrow night, if there is to be any hope at all of us getting through the business that is on the order paper, on the business papers, and therefore on the daily order papers for this meeting. So it's not about trying to keep them from saying what they want to say or have the opportunity to deal with emotions, but they will be the first to get up and say that I have mismanaged the business of the House, and therefore the business has not been completed. I will endeavor to ensure that the business is completed, Madam Speaker. That is my only objective.
Member from Easton.
Thank you, Madam Speaker. Madam Speaker, I am not going to get up and say that the Premier has mismanaged the business of the House. That's why the business didn't complete. I'm going to tell him that he's trying to mismanage it so ours can't get completed. But his is going to get completed. That's what his intent is. But his business, our business, is as important as his is. And you don't think so? It isn't? It isn't. You see? You see? Madam Speaker, you know, he listed all the things on the order paper, Madam Speaker, and he listed 10 private members' motions. Absolutely. That are left. When does the opposition get the opportunity to do it? He speaks with the leader of the opposition. The leader of the opposition don't control me. There are independent members here, but he considers so little in here, in his infinite wisdom and power that he thinks he has, that he dismisses us. And it's unfair because we represent a certain sector of this society as well. And by dismissing us and our work on behalf of the people By extension, he's dismissing the people as well. But Madam Speaker, be that as it may, it won't be no dismissal soon.
The question is that Stand Order 14.3 be suspended to allow, excuse me, to allow government business to take precedence over private members' business. All those in favor, please say aye.
Aye.
Against, no.
No.
I believe the ayes have it.
Division, please.
Madam Clerk, please call a division.
Honorable Alden McLaughlin.
Aye.
Honorable Moses Kirkconnell.
Aye.
Honorable Kurt Tippett. Honorable Moses Oswald Bodden.
Aye.
Honorable Wayne Panton.
Aye.
Honorable Marco Archer.
Aye.
Honorable Tara Rivers. Mr. Roy McTaggart.
Aye.
Mr. Joseph Hugh.
Aye.
Honorable Kiva Bush. Mr. Bernie Bush. Captain Eugene Ebanks. Mr. Alva Saku.
No.
Mr. Winston Conley. Mr. Ezra Miller. Mr. Arden
No.
McLean.
You don't want me?
Mr. Ezra Miller.
That's two.
No.
Mr. Arden McLean.
No. Do I get another?
Honorable Anthony Eden.
There is the results of the division are as follows: 9 ayes, 4 noes, 4 absentees. Motion is carried. Honorable Premier, can you move the motion for the adjournment?
Thank you, Madam Speaker. Madam Speaker, I move the adjournment of this honorable House until 10 a.m. tomorrow, sharp.
The motion is order that the Honorable House be adjourned until 10 a.m. tomorrow morning sharp. All those in favor, please say aye. Against, no. The ayes have it. The House is accordingly adjourned until 10 a.m. tomorrow morning sharp.